019-00269, application of Big Rivers Electric Corporation for enforcement of rate and service standards. My name is Michael Schmidt. I'm chairman of the commission, and with me today in another location is Dr. Talina Matthews. Vice Chairman Kent Chandler has recused from this proceeding because when it was initially filed, he was with the Office of the Kentucky Attorney General and apparently gained some information about it. So, at this time, we have because this is a virtual hearing, we have some protocols and suggestions for counsel and the parties with respect to how we proceed. So let me read those first before we begin. At this time, I would normally caution attendees to please set your cellular phones to silent mode or turn them off. Due to the current state of emergency in Kentucky, the Commission is hosting this hearing via video conferencing. Since this continues to be a learning experience for everyone, there are a few suggestions I would offer. In addition to the normal courtesies regarding cell phones, these tips may help with clarity and avoid feedback issues for the video conference hearing. First, mute your microphone if you are not speaking. Attorneys, when interjecting, making an objection, please state your name so the video record is clear. If you use a phone for the audio and a computer for the video, turn off the computer audio, otherwise there will be feedback. If you are in a room with several people on their own computers, turn off the computer audio for all but one computer. Otherwise, there will be feedback. If another participant is in a nearby office, close the doors between the offices. Sound carries further than one thinks, which can cause feedback. Once in the GoToMeeting software platform, go to your settings, icon looks like a gear, to ensure the microphone setting is on the microphone you are using. There's a pull-down feature in GoToMeeting settings that will list the available microphones. Use wired headphones or wired earbuds for better sound quality. Wired is preferred because wireless devices may lose power depending upon the length of the hearing. Keep a charger nearby in case your battery runs low, and please alert the Commission if you are experiencing technology failure that prevents your participation at any time in the proceedings. Attorneys should contact staff at the previously provided cell phone number. I will say that on occasion in the few of these hearings we've had, someone will get disconnected. And if that occurs, we will stop to allow time for you to become reconnected, but you may need to call in and advise our people if you are off. The purpose of the hearing today is to take evidence in case number 2019-00269, application of Big Rivers Electric Corporation for enforcement of rate and service standards. Parties to this proceeding are Big Rivers Electric Corporation, the City of Henderson, and Henderson Utility Commission, DBA Henderson Municipal Power and Light. At this time, would counsel for Big Rivers please identify himself, co-counsel, his client, and the witnesses who are available to testify this morning.
Thank you, Mr. Chairman. I'm Tyson Kamoff, corporate attorney for Big Rivers Electric Corporation. I also have in the room with me two other in-house attorneys, Greg Mays and Cynthia Santana. Seated next to me is our co-counsel, Mike Kurtz, with the law firm of Van Kurtz and Lowry, and his associates are also in the room, Jody Cohn and Kurt Bain. We have all but one of our witnesses in the room, so our CEO, Bob Berry, our CFO, Paul Smith, the Vice President of Operations, Mike Chambliss, the Vice President of Energy you said, it's Mark Akert, and the Executive Vice President of Operations, Mike Pullen. Our other witness is Jim Cobb, who is
I'm sorry,
participating.
was there some feedback or something?
Hard to hear you. That was up.
All right, so our other witness is Jeff Cobb, who is participating remotely.
Okay, thank you. At this time, would counsel for the City of Henderson and the Henderson Utility Commission please identify himself, co-counsel, his clients, and witnesses who are expected to testify in this case.
Thank you, Commissioner Smith. My name is Randall Redding, and I represent Henderson Municipal Power and Light, referred to as Hempel, and the City of Henderson, which we refer to as the city. And my co-counsel is John Hughes and Sharon Farmer, and they are not on the Go meeting link. They are watching live. They are available. I have with me the general manager of Hempel, Mr. Chris Heimgartner. I have Barbara Mall, the CFO for Hempel. I have the Reliance officer, Brad Bickett. We have by remote Chris Dawson and Seth Brown.
Thank you.
And I would ask, Commissioner, could we have the phone number? You mentioned we could call in if there was a disconnect. Do we know that number?
I emailed that to the parties on Monday afternoon. I can email it again.
Hey,
now.
Mr. Nguyen, our staff counsel, says he sent an email Monday with that phone number, but he will now email it again. Is that
Yes.
correct? So if you have your a phone handy, you should get an email with the number. After we finish identifying the parties and having the phone call, Mr. Redding, if you still don't have the number, we can get it and I'll announce it so that you can have it available. At this time, would counsel for commission staff please identify himself, any co-counsel?
Yeah, yes, Your Honor. Thank you. Quan Nguyen and Ben Bellamy, who's attending remotely on behalf of the commission.
I understand there are some outstanding motions. I believe there are confidentiality motions. Is that correct?
That's correct.
Are there some that have not? And those will be ruled upon at some time after the conclusion of this hearing. If at any time it appears that a witness is beginning to testify about matters that a party considers confidential, please let us know, and that we will go into executive session or confidential session so that testimony can be heard without breaching or compromising your position on confidentiality. I saw there are also some motions by City of Henderson and the Henderson Utility Commission which involve, I guess, a motion to file amended testimony of Mr. Heimgartner, then another motion, I guess it was filed yesterday or today, a second motion to file second amended direct testimony of Mr. Heimgartner, a motion to file amended testimony of Barbara Mall, and to amend, it looks like exhibits 10.2020. Maybe it's just exhibit 10. Is there any objection to those proposed amendments?
Big Rivers has no objection.
Okay. In that case, the motions, all those motions will be sustained. Are there other motions that I have not identified that at some point need to be ruled on? Okay, I take it that there are none. I checked the record, and the notice, public notice, has apparently been given and filed in the record. Is that correct, Mr. Kamuth?
That is correct, Your Honor.
Okay. All right, at this time, we will open the proceeding for public comment. Should anyone from the public like to provide the commission with public comment, Instructions to call in are located on our website, psckentucky.gov. The phone lines will remain open for several minutes at the start of the hearing and close if there are no callers or after everyone has had an opportunity to speak. Should you call in, please state your name and address for the record before making your statement, and please keep your comments to 5 minutes or less. If there is more than one caller, please be respectful and allow one person to make a statement at a time. It should be noted that comments may always be submitted on the Public Service Commission's website at psc.ky.gov. Mr. Nguyen, at this time, are you manning the telephone there or the system?
I am, Your Honor. The line is
Public
open.
comments? Okay, thank you. We'll wait a couple of minutes to see if anyone is interested in calling in and making a comment. Mr. Redding, have you received the phone number?
I have not, Your Honor, but obviously my staff is listening. I would assume if there's a problem that
Do you have the number? Can
They
we
will
read
be
it on
Sure.
the record?
I now have it, but I just received it.
I'm going to ask Mr. Nguyen to read the phone number into the record at this
Sure.
time, so if you have your pen, you can write it down.
Sure, it's 770-403-4405.
I now have it.
Okay, thank you. Apparently, there's no one who is interested in calling in at this time with a comment. So we can begin the proceeding with Big Rivers calling its witness, and after that, the City of Henderson will be able to conduct cross-examination. And after the cross-examination is completed, Mr. Nguyen or Commissioner Matthews or myself may or may not have questions, but whenever that is completed, Mr. Redding, you'll have or Mr. Kamouf and Mr. Kurtz, you'll have an opportunity to conduct a redirect examination to clear anything up that you may desire to do so. So at this time, Mr. Kamouf and Mr. Kurtz, would you like to call your first witness?
Yes, Your Honor. Big Rivers calls its CEO, Robert Berry.
Okay, Mr. Berry, will you please raise your right hand? Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Okay. Counsel, you may ask.
Thank you, Your Honor. Would you state your name and business title for the record, please?
My name is Robert Beery. I go by Bob. I'm the president and CEO of Big Rivers Electric. Our address is 201 3rd Street, Henderson, Kentucky, 42420.
Do you have in front of you two sets of testimony, direct and rebuttal, that was prepared by you or under your direct supervision?
I do.
If I were to ask you the same questions as those contained therein, would your answer be the same?
Yes.
Do you have any additions or corrections to your testimony?
I do have two additions that I would like to present this morning. First, on September the 21st of this year, Big Rivers filed its Integrated Resource Plan, IRP. A part of the optimal plan under the base case assumptions recommend that we idle our green generating plant on June 1st, 2022 and build a combined cycle natural gas plant. That's significant because shortly thereafter, Big Rivers will close and decommission the Green Station landfill. Idling the green units on June 1st, 2022 now puts more certainty around the near-term decommissioning of the green landfill, which is one of the disputed items in this case. Additionally, in my direct testimony, we provided estimated costs for decommissioning Station 2. We have since received bids for decommissioning our Coleman facility, and they were much less than what we anticipated. The Coleman units in Station 2 are almost identical, and although there's 3 units at Coleman and only 2 units at Station 2, we expect the bids at Station 2 to be slightly higher than those for Coleman for a couple of reasons. One, for the decommissioning at Coleman, we will not be decommissioning the Coleman scrubber because that scrubber will be moved to Wilson per our environmental compliance plan. Also, there are some issues at Station 2 that make decommissioning those units just a little bit more complex, such as the 2 green units are still in operation in nearby proximity, as well as the Reed combustion turbine. So it does make it a little more complex. But we do believe that decommissioning Station 2, the bids for Coleman is probably representative of what we might see for the decommissioning costs of Station 2, and we expect those costs to be somewhere between $3 and $6 million.
Does that conclude your summation?
Yes, sir.
Your Honor, the witness is tendered for cross.
Mr. Redding, cross-examination.
Thank you, Commissioner. Mr. Berry, Randall Redding for Hempel. Before I ask you some substantive questions, is it my understanding that there will be testimony presented either through Mr. Pullum or some other Big Rivers representative that has recalculated or adjusted the amount of waste in the calculations relating to the green landfill?
We have provided, I'm not certain if Mr. Pullman will speak to that, but I believe that he will, yes.
If not, is it my understanding that Big Rivers is recalculating that to arrive at the appropriate amount of waste that's in the green landfill related to the green station that predated 1995?
That's correct. The calculations, it's been recalculated to determine the volumes in the landfill based on the operation of the green units prior to 1995, as well as prior to 95, only bottom ash and fly ash from Station 2 was going in the landfill. So those numbers have been adjusted, and Mr. Pullen can speak to those more specifically.
Mr. Berry, we realize, though, the commission may soon, when they look at the financial data, that there is a dispute as to some revenues with the revenue associated between the time period of June of 2016 and December of 2017, which what I will call the unwanted energy revenue period.
I'm sorry, I did not hear a question there.
Let me explain that. Is there a dispute between the parties involving revenue to be provided to one or the other party between the time periods of 2016, June of 16, and December of 17?
I think there's a dispute regarding the settlement agreement that was signed in December of 2017 and payment made in January of 2018 that appropriately identifies the revenues and payments for that excess Henderson energy.
But you do agree with me that in the 2016 filing, that Big River's application addressed what you defined as unwanted or unprofitable energy.
I believe the 2016 case resulted in identifying excess Henderson energy that was unprofitable, but it's all excess Henderson energy.
When you filed your petition in 2016, you defined the proceedings that are before this commission today are dealing with what is known as unwanted or unprofitable energy. That was your sworn testimony to the commission, was it not?
I have had to be subject to check. I have to go back and look. I've not looked at the 2016 testimony in preparation for this hearing today. But I will say that all energy in 2016 as well as today is excess Henderson energy. Some of it's profitable, some of it's not, some of it's wanted, some of it's not. But the only energy that should be in dispute between either party is excess Henderson energy, which is defined as the difference between their load, Henderson's load, and their actual reservation on an hourly basis.
That's the position Big Rivers takes, but you are keenly aware that Henderson disagrees with that position, are you not?
Oh, I'm aware that Henderson disagrees with that position.
And during this time period, and when the hearing in 2016 was held, you represented to the Public Service Commission that if Henderson accepted the variable cost under your request, that Henderson would be entitled to the revenue from the unwanted excess Henderson energy to offset those costs. Did you not?
Well, subject to check, but I do know that subsequent to that testimony, there was a settlement agreement that resolved all excess Henderson energy, both past, present, and future. And there was a payment of $6.25 million made to the city that resolved all of those issues.
And when the commission in 2018 issued its ruling addressing the responsibility of variable costs for the unwanted excess Henderson energy, the record before the commission represented that Henderson would be entitled to the energy, did it not?
I don't know. I have not looked at that record.
And at no time did you advise the commission that Henderson was no longer entitled to the revenue from the excess Henderson energy under your 2016 declaratory action request.
Can you repeat that, please?
At no time did you amend your testimony or advise the Public Service Commission that Henderson was no longer entitled to that revenue in your declaratory judgment action request to them.
I don't recall if my testimony.
If you did, would you be so kind as to supplement that into the record to this commission?
Absolutely.
And if you do not supplement that, can we assume that you did not advise the commission of that?
I don't know how to answer that, Mr. Redding.
You either did advise them or you did not.
Pardon?
You either did advise them or you did not.
And currently, at this moment, I don't recall if we did advise them or not.
And Big Rivers, during that time period of June of 16 through December of 17, received revenue of $10,696 on this unwanted excess Henderson energy, did it not?
I don't know that exact number. It is in the calculations, I believe, in this case, and Mr. Smith can speak to those numbers more specifically. But as I stated earlier, January the 4th of 2018, Big Rivers made a payment to the city of Henderson for $6.25 million to resolve all of those issues.
Well, let's talk about that thing. in your filings with the petition, you state that Big Rivers made that payment, but who funded that payment?
Big Rivers wrote that check to the city of Henderson, and it is made from Big Rivers.
Did Eon reimburse Big Rivers for that money?
Eon made a payment to Big Rivers to basically be relieved of their obligation under the indemnity agreement. And at that point, we took part of that money and we used that to settle all the excess Henderson Energy issues that we have with the city of Henderson.
Did Big Rivers reimburse you for the $6.2 million that you're referencing in your testimony? Eon.
Yeah, Big Rivers.
Eon reimbursed?
Eon paid Big Rivers a sum of money to get out of their obligation under the indemnity agreement. And what Big Rivers did with that amount of money was up to Big Rivers.
How much did Eon pay you?
The exact amount was a little bit north of 10 million.
And during this disputed time period in June of 16 through December of 17, Big Rivers also sold profitable energy, did it not, and received revenue?
That's correct. We sold excess Henderson Energy at a profit during that time.
And that profit, according to Mr. Smith's testimony, is $2.48 million.
I think you have to ask Mr. Smith that question. I would not want to testify to his testimony.
And under your, and the variable cost that you've presented for this time period for unwanted excess energy was $10,688,000. Correct?
Again, you'll have to ask Mr. Smith if that's in his testimony. I think he would be the appropriate person to ask those questions to.
And you remember that you were a party to the 2009 civil action, which was the subject matter of the release that you're referencing, were you not?
I'm very familiar with it, yes, sir.
And that complaint in its prayer asked Big Rivers to disgorge itself of revenues from the profitable excess Henderson Energy, did it not?
Are you speaking to the case in the Henderson Circuit Court?
Yes?
So what I recall is in that case, Henderson was seeking reimbursement or damages for excess Henderson Energy that was taken by Big Rivers, that the city had made the accusation that Big Rivers blocked them from taking that energy.
And it specifically referenced profitable excess energy, because you couldn't sue for negative, could you?
It was it was for excess Henderson Energy, which was wound up being a part of the arbitration between the parties, and it defines excess Henderson Energy as the difference between Henderson's reservation and their actual load on an hourly basis. It's the same definition that the commission used in the 2016 case. That is again, the difference between Henderson's reservation and their actual load on a given hour.
Were you aware that the civil action that was filed, its only request in the actual pleading was for the damages related to profitable excess energy for the revenues that Big Rivers had received? It's yes or no?
I can't speak to that. I don't know.
Assuming that is correct, you were aware, were you not, that the release that you're referencing to this commission was specific that the release will only apply to Civil Action 09 CI 693, hereinafter referred to as the damages suit.
Are you
The release
speaking?
that you filed, the release that you have filed with the PSC.
Are you saying, you're talking about the 2017 settlement agreement?
Yes, sir. Sir.
The 2017 settlement agreement releases all claims and settles all excess Henderson Energy claims, both past, present, and future. I was in those negotiations, as were you, and if you recall, on December the 12th, 3 p.m. in the LG&E headquarters, I was ready to get up, and I got up, closed my book to walk out because you guys wanted, Henderson wanted to categorize different categories of excess Henderson Energy, profitable, unprofitable, wanted, unwanted. And I said, no, if I'm going to pay $6.25 billion, it's going to resolve all the cases in excess Henderson Energy because you've already been paid for it twice. I don't want you to take my money and sue me a third time for it. So that was the dispute. And Mr. Heimgartner and I broke out in a conference room for about 20 minutes, and we came back in, and Henderson agreed to the language in the 2017 settlement agreement that specifically says it releases and resolves all claims past, present, and future, as well as Henderson's own audited financial statements represent the exact same language that I'm mentioning to you today. That's what I know.
Mr. Commissioner, before I ask my next question, let me note my objection. I object some self-serving testimony from a hearing, from a settlement meeting. But with that said, Mr. Barrett, and I can read the release or you can pull the release. The release specifically says, this release shall relate to and be to the damages claimed in Civil Action 09 CI 093. If I'm reading that correctly, do you have any objection to that being the language that's in the release the commission will see?
Well, I think that would be subject to check, because there's other language in the same release that talks about releasing all cases that you have, ever did have, or ever will have, going forward. So I think you can't take one sentence out of that agreement and try to say that that was the intent of the entire agreement.
Let's visit with the calculations of what you are presenting to the PSC, that you're asking them to accept your calculations and disregard this dispute. But correct me if I'm wrong on these calculations. You're asking the commission that you receive the $10 million in excess Henderson Energy revenue for the time period during June 16th through December 17th, are you not?
Actually, it's my position that Hempel accepted those calculations when they agreed to be paid $6.25 million to resolve all those issues.
You're asking the commission that you be allowed to keep that revenue.
We're asking the commission to agree that the settlement agreement covers all of those issues and resolves all those issues.
And you're also asking the commission that you be allowed to keep the $2.4 million during that same time period for profitable energy, are you not?
We are asking the commission to agree that the settlement agreement, or interpret the settlement agreement, which reads that it resolves all excess Henderson Energy issues, past, present, and future. In that same settlement agreement, Big Rivers waived its right for excess Henderson Energy going forward after January the 4th of 2018, and that all excess Henderson Energy going forward belongs to Hempel, and that Hempel would pay the variable cost. And I think those are very close to the exact language that's in that settlement agreement.
And contrary to what the record reflected when the commission entered an order in 2018, you're asking for Henderson to pay the variable cost of $10 million, that Big Rivers gets to keep the revenue of $10 million on the unwanted excess Henderson Energy. And in addition, Henderson would have to write off $3.5 million of coal, are you not?
I'm asking the commission to require Henderson to honor the 2017 settlement agreement that they willingly signed and negotiated, which resolved all of those issues.
If the commission believes the release that you're referencing was limited to profitable energy, then Henderson would be entitled to the revenues to set off against the variable cost as you represented in the 2016 hearing, would they not?
Can you restate that question, please?
If the commission finds that the release is limited to the profitable energy in the 2009 civil action, then Henderson would be entitled to the revenues from the unwanted excess Henderson Energy that was the subject matter of the 2016 hearing.
So nowhere in the settlement agreement does it mention profitable energy. It mentions disputed energy and excess Henderson Energy, which is the same definition that the commission used in 2016 and the same definition that the arbitration awards in the arbitration that actually was appealed all the way to the Kentucky Supreme Court. So I think the settlement agreement is clear. It resolves all those issues, past, present, and future.
Mr. Berry, I will continue to ask this question. If the commission finds that the release that you're referencing does not apply to the unwanted excess Henderson Energy, then you will agree that Henderson is entitled to those revenues to offset against those variable costs.
Chairman Schmidt, I have an objection on the basic point that this has already been asked and answered, plus it misconstrues the release agreement, which applies to all excess Henderson Energy, not just a subset. So I object to the question.
Well, I think that ultimately we'll be receiving other testimony on this point, and it comes down to a question of interpretation. I think the question has been asked, and to the extent the witness intends to answer, he's already done that. So, Mr. Redding, we probably ought to move along. I think we understand your point.
Thank you, sir. I think that's all I have, Your Honor.
Okay, thank you. Mr. Nguyen, any questions of Mr. Berry?
Yes, Your Honor, just a few. Good morning, Mr. Berry. Can you hear me okay?
I can, thank you.
Can you refer to your rebuttal testimony, page 12 of 30, please? And
Can you repeat that page, please?
it's page number 12 of 30.
Okay.
Okay, in the middle of the page, you list certain required or mandatory decommissioning activities that will need to take place at the Station 2 generation station. and you identify some federal regulations regarding the disposal, the coal combustion residuals rule, the CCR rule, federal rule regarding spill prevention, control, and countermeasure plan, the National Pollution Discharge Elimination System, as well as the regulation on National Emission Standard for asbestos, and also Surface Mining Control Reclamation Act and the Resource Conservation and Recovery Act. Can you identify, with respect to those regulations or statutes, which facility or assets at the Station 2 that would need to be decommissioned first? Are you able to do that now, or would that be more appropriately through a post-hearing data request?
It may be more appropriate in a post-hearing data request. I could probably answer some general questions on those today.
Sure, that'd be good.
So are you asking what activity is required to comply with each one of those?
Yes. So, for instance, the CCR rule, we understand that that's going to impact the Station 2 ash pond. Are there any other facilities that will be impacted by the CCR rule?
Not that I'm aware of, just off the top of my head, but it's really, we have to close the Hempel Ash Pond, and I believe the date per the CCR rule is April of 2024. It has to be completely closed.
Okay. And then what about the spill prevention, control, and countermeasure plan?
I'm sorry, but under that CCR rule, there is also a requirement of 30 years of groundwater monitoring that is required following the closure of that plant.
Okay.
Okay. The spill prevention and control countermeasures means that any type of hazardous waste, fluorocarbons, anything that we have on site that we either needs to be removed from site, or you need to continue to maintain your spill prevention and control countermeasure plan. And I'm talking about different solvents, paints, or anything like that that's on site.
Okay, what about the NPDES?
The NPDES is really has to do with the runoff and discharge of the current ash pond, and then any stormwater runoff, coal pile runoff, those items that are required to stay in compliance within that NPDES permit. It's a specific permit, and those limits are listed on that permit.
Okay. So are there other facilities that accept those type of runoffs other than the ash pond?
Yeah, there's a coal pile runoff pond
Okay.
that receives, any rainwater, stormwater runoff from the coal pile, so that it's not discharged improperly.
Okay, so that has to be, when you say decommission, what do you mean? Does it has to be fully retired according to whatever the regulation provides?
If that means fully retired, and in the case of the ash pond, it has to actually be closed, capped off, and with a certain amount of soil over top of the ash, and then sown in grass.
And that would be pursuant to what the regulation would require, correct?
Yes, sir.
Okay. And then what about the asbestos standards?
Okay, so in the asbestos standard, you have to be able to, manage your asbestos, no exposure. If you do have exposure, if you have asbestos that's friable and the things become airborne, you have to basically rope off or, make countermeasures in order to keep any kind of asbestos exposure there.
Okay.
So you have to continue to maintain that asbestos. You have to walk it down, make sure there's none friable that's fallen off and that has the potential for human exposure.
Okay, so to the extent that if Station 2 remains retired in place, certain areas of the station that contains, that has asbestos-containing material will need to be, did you say roped off or segregated or contained somehow? So measures that are put in to contain activities within the area so that the asbestos, so that it wouldn't agitate the asbestos containing materials that are located in those areas.
Yeah, so you would barricade off, basically Station 2 if it's retired in place, and then someone would need to walk down the unit on a pretty frequent basis to confirm that no asbestos has fallen off the pipes or off the turbine or wherever the asbestos is located. And then if it has, then you have to take the proper cleanup measures, because, if it's on a really windy day, it could actually, blow beyond the barricaded area that you have barricaded off.
Okay, so the entire station has to be cordoned off.
That's correct, and it's important because we have Green Station that's adjacent to Station 2. So if we want to make sure that we don't have any exposure to the employees there in the Green facility.
Okay, and then what about the Surface Mining Control Reclamation Act? What facilities or assets will need to be addressed related to this particular statute?
And that's really cleaning up where the coal pile is located, actually removing any residual there, and bringing that back to a brownfield or greenfield site.
Okay. And then the Resource Conservation Recovery Act, which facilities would be impacted by that particular statute?
I think that's one I probably need to do a little more research on to give you an adequate answer.
Okay. And then what I would also like is any projected or estimated costs associated with each one of these compliance measures related to the regulations or the statute that you've identified as well. And I'll include that as part of a post-hearing data request.
Okay.
You give me 1 second, I'm just going to jot a note here for that. So if you could, please turn to page 13 of your rebuttal testimony. Lines 21 and 22 at the bottom of the page.
Okay.
So those lines, you state that should Henderson choose to simply abandon Station 2, then Henderson must bear any resulting costs, including EPA penalties. Could you provide support for this particular statement, particularly regarding the EPA penalties that would be obligated by Henderson upon abandonment? And I guess, what do you mean when you say abandoned?
Well, what that means is if Henderson decides just to walk away from Station 2 and not provide any decommissioning, they decide not to manage and continue to maintain as if it's retired in place. In this case, specifically the Henderson ash pond or Station 2 ash pond, if that ash pond is not closed by April of 2024, there are EPA penalties that will be assessed to the owner of that pond.
Okay, so the penalties are associated, or the obligation flows from the ownership of that particular facility?
That's correct.
Okay. Were there any other EPA penalties that would be covered under this statement as well, other than, a potential violation of the CCR rule?
I mean, there could be others, such as if Henderson decides to walk away and not maintain retirement in place or decommission and abate the asbestos. If there's asbestos exposure and friable asbestos that's allowed to be released in the air, EPA as well as OSHA could have some penalties as well. Stormwater runoff, if it's not maintained properly and and that runoff gets discharged to the river and it's above the KPDES permit limits, then there will be penalties associated with that from EPA as well.
And those are similar to the CCR rule in terms of the obligation belonging to the owner of those facilities as well?
That's our position, yes, sir.
Okay. And when you say that's your position, is that the position based upon your reading of the regulations or the statutes, or what's
Yes.
that position based upon?
It's our interpretation of the regulations.
Okay. So can you turn now to page 15 of your rebuttal?
Okay.
Similar to the questions that I just asked you, lines 10 through 14 on this page, you state that the cleanup of Station 2 after its operating life was expressly contemplated in the 1993 amendments, and Henderson should be held to its contractual commitments to share in the decommissioning costs or absorb all of the retirement in place costs of the power plant it owns. Can you provide a little bit more detail and support regarding the portion of the statement in which you say that the cleanup of Station 2 after its operating life would be, the statement regarding that the cleanup of Station 2 after its operating life was expressly contemplated in the 1993 amendments?
Yes, so prior to the 1993 amendments, Big Rivers had no contractual obligation for any decommissioning cost. And I believe in the 93 amendments, if Big Rivers agreed to extend the operation agreement through the end of the useful life of Station 2, then Big Rivers would now be responsible for, and I'm going to give you round numbers, 78% of the decommissioning cost. But there's nothing in the contracts that says Big Rivers has any responsibility for retirement in place costs. It just says that Big Rivers is responsible for 78% of the decommissioning cost.
Okay, so you're saying prior to the 1993 amendments, there was nothing in the various Station 2 contracts that address or that would require Big Rivers to be obligated in any fashion with respect to the decommissioning costs associated with Station 2?
That's correct.
Okay. But with the 1993 amendments, and I think you mentioned that after Big Rivers had, was this after the extension of the Station 2 contracts?
That's correct. I think the initial contracts were to expire in 2003, and the 1993 amendments extended the contract through the useful life of Station 2. And at that point is when the decommissioning language was inserted that said the parties would share on the decommissioning costs based on the amount of capacity each party took out of that station over the life of the station. And when you do that calculation, it's about 78%. For Big Rivers and 22% Hempel.
Sure. And was the decommissioning costs, the allocation, was that something that was raised by the city, or was that something that was raised by Big Rivers in terms of, anticipating when the Station 2 would need to be retired and those costs associated with its retirement. Do you know which party, raised that particular issue?
I do not.
Okay. And okay, to the extent that you mentioned that the absorbment of all of the costs related to if Henderson decides to continue with the retirement in place, that obligation would be solely upon the city. Is that correct?
Yes.
Okay. And your support for that is that in the contract or in the amendment, there isn't any provision that addresses retirement in place. So absent that, Henderson is obligated 100% of any retirement in place costs.
That's correct. The contracts were, I believe, very clear that both parties anticipated when the end of the useful life of Station 2 that it would be decommissioned, which is why they put the decommissioning language in the contract, and why there was no language in the contract that references retirement in place.
Okay. So can you turn now to page 17 of your, I'm sorry, let me check this 1 second. I'm sorry, turn to page 23 of your rebuttal testimony. At lines 1 through 4 regarding the expansion of the Green Station landfill.
Okay.
Give me 1 second. Okay. You mentioned that the expansion of the Green Station landfill was driven by the accumulation of the Station 2 waste. Is that correct?
So it was driven by both parties, Green Station continue to operate, as well as Station 2 to continue to operate. However, had Big Rivers not been putting the Station 2 ash in that landfill since, ash and Positec since the beginning, bottom ash and fly ash since the beginning, but Positec beginning in 95 when the Hempel scrubber went into commercial operation. If all that scrubber sludge from Henderson had not been put in that landfill, Big Rivers would not have been required to put the wall in to allow some additional room in that landfill for going forward purposes.
Okay. So is it, well, on line 3, begin on line 3 to 4, your testimony, the rebuttal testimony states, but for the accumulation of the city's waste, the vertical expansion would not have been necessary. So are you saying that the expansion of the green landfill is driven directly by the disposal of Station 2 waste in the landfill?
That's correct. If the scrubber sludge from Henderson or Station 2 would not have been going to the landfill. There would have been no need for vertical expansion or putting the wall in for expansion.
Okay, and I think you touched upon this at the very beginning of your testimony in terms of any additions that you may have. And you mentioned that there are some recalculations to the amount of the Station 2 waste that is contained in the Green Station landfill. Is that correct?
That's correct. What we've tried to do is base the financial obligation from each party based on the volume of material that is stored in that landfill. And when our initial calculations were made, we did not include the scrubber sludge for the green units from the time they went in commercial operation until 1995. We only started in 1995. And so the city brought this to our attention, and they are correct, and that calculation needs to be adjusted, which will, and I think in the testimony, it was showing that Hempel's responsibility for that landfill was about 12% roughly, maybe 11.9 or something, but, and I think those new calculations takes it down to about 9.8%.
Okay.
Uh,
So you're saying that the Station 2 waste accounts for about almost 10% of the volume in the Green Station landfill currently, or is that over time?
So currently, well, I'll make sure I answer your question correctly. So that 10% means what's in the landfill today
Okay.
is about 10% of that ash came, or 10% of the material came from Station 2.
Okay.
Let me clarify that,
Sure.
if I may. So there's really more than 10% of the waste in that landfill that belongs to Station 2. However, so the way the calculation works is you first see how much belongs to Station 2, and then Big Rivers is responsible for a certain percentage of Station 2. So that 10% is the amount of waste that's left in the landfill that's attributable to the energy that was taken by the city of Henderson.
Okay, so so the total Station 2 waste, if you include the energy that was taken by Big Rivers, would be more than 10%?
Yes, sir.
Okay. Okay. And that percentage would be, the total amount of Station 2 waste would be, would you say it would be significantly more than 10%, given that Big Rivers took the majority of the energy that was produced by, more than half of the energy that was produced by Station 2?
Yeah, so the 78% obligation in decommissioning essentially means Big Rivers took 78% of the capacity of those units over the life of the station.
Okay. Can you move down to lines 5 through 9 on page 23 of your rebuttal?
Yes.
Okay. You mentioned the the cost comparison to dispose the Station 2 waste at the Green Station landfill with an off-site commercial landfill, and the savings that that was inherent in the city using this Green Station landfill. And you mentioned that the savings was about $3.1 million since 2015. What is the comparison based upon? Was it based upon a nearby commercial landfill, or could you provide that information in terms of what the basis for that comparison was?
And so if you look at the amount of ash that the Henderson's portion of the amount of ash that went into that landfill is about 525,000 ton roughly. And it would be an additional $6 per ton to truck that off-site by either building a new landfill or going to some type of commercial landfill. We have looked at those pricing because when we were doing the expansion, we were trying to evaluate the most cost-effective a way of extending the life of the landfill. Would that mean build a wall, or do we build a new facility off-site, or do we truck it to our Wilson facility, which did have enough capacity for it? And so that's how we knew that it would be about $6 a ton incremental to what they were currently paying.
Is that a market price for, that you arrived at, the $6 per ton?
Well, I would call it, I guess you could call it a market price. It's essentially, the cost of either building a new landfill and managing it along with the trucking that it takes to haul it off-site, permitting for to haul it across the highways.
Okay, so it was the derivation of that $6 per ton for trucking the waste was basically building a new landfill and trucking that off-site.
That's correct. Or taking it to a commercial landfill. I think we looked at taking it to a commercial landfill as well.
Okay. And there are nearby existing commercial landfills that would be able to take these type of waste?
There are commercial landfills. I wouldn't call them necessarily nearby. I'm thinking you're probably looking 30, 40 miles away. But I'm not certain on that.
Okay.
It's something that I would have to do some research to tell you the exact locations.
Okay, but those also fell within the $6 per ton? Fee?
Yes.
Okay. Can you turn now to page 24 of your rebuttal testimony, lines 14 through 15? And this is regarding your statement, in which you said that Big Rivers would be legally prohibited from taking title to the Station 2 waste because of the nature of the Green Station landfill permit. Can you provide more explanation as to the Green Station landfill permit and why, under the provisions of that permit, Big Rivers would not be able to take title to Henderson's Station 2 waste in that landfill?
So I'll give you as much as I possibly can here. The landfill currently is permitted as a special waste landfill, and it's only for putting bottom ash and fly ash from our units in that landfill, along with scrubber sludge. If we started taking title from another party and putting their material in that landfill, then it would become a commercial landfill, and it would fall under a totally different regulation and permitting process.
Okay, so the permit itself specifies the owner of the waste that will be accepted in that particular, in the Green Station landfill, is that correct?
I don't know if it specifically says owner, but it's basically saying that you can put the waste that your plants, that you're owning or operating, what that creates, you can put that waste in the landfill. However, you can't start putting other parties' waste. You can't be paid to put other parties' waste in your landfill.
Okay.
Then you lose your special waste permit. And the restrictions on a commercial landfill are much more stringent than what they are on a special waste landfill.
Okay. Just want to switch now to your direct testimony. At the bottom of page 17 and the top of page 18. And you compare the typical residential customer rates for the city versus the 3 Big Rivers Distribution Cooperative. Okay, and you mentioned that a typical residential customer would have a monthly bill of about $84.90 for that's served by Henderson. But a customer for Jackson Purchase would have a monthly bill of $117.18. Kenergy's customer, residential customer, will have a monthly bill of $120.24. And Mead's residential customer would have a monthly bill of $114.82. Do you see that?
Just one moment, I'm
Sure.
listening, but I'm getting there. This book is not going to cooperate, so. You had it, yeah. Okay, I'm sorry, go ahead now.
Yeah, no worries. So do you see the language where you made that comparison?
Yes,
Okay. And then you state at the top of page 18 that the discrepancy is due in part to the fact that Big Rivers has borne costs that Henderson was obligated but refused to pay. Could you provide additional information regarding this statement about the discrepancy being due in part to Henderson's refusal to pay costs that they were obligated to pay under the Station 2 contracts?
is that something you want in a post-hearing data request, or just verbally, or?
It's up to you. If you're able to address it now, then please do. But if you feel more comfortable addressing it more fully in a post-hearing data request, we could do that as well.
Just 1 second here. Yeah, let's do that in a public hearing data response if that's acceptable to you.
Sure. And what I would like is, and I'll have this in the post-hearing data request, but if you could identify which or what obligation that Henderson had refused to pay under the Station 2 contracts that would have caused this discrepancy in the rates paid by the 3 Big Rivers customers of the 3 Big Rivers distribution cooperatives, and the monthly payment of a residential Henderson customer. Okay. Those are all the questions I have, Chairman.
Commissioner Matthews, questions?
I don't have any, thanks.
I just have 2 or 3. Mr. Berry, who at present what is Big River's position as to who actually owns Station 2? The land, the plant, the equipment?
So it's Big River's position that Henderson owns Station 2. They've owned Station 2 for 47 years, and they've made no bones about it. They have complete control of it and own Station 2. I don't want to speak for their position, but typically they think that once the units quit operating, it now belongs to Big Rivers.
Did Henderson actually build and pay for Station 2?
So the Station 2 was built using tax-free bonds through the city of Henderson. But Big Rivers actually, I guess, was paid more than 90% of the cost to build Station 2. And that's the extreme benefit that Henderson has received out of Station 2. They had a large generating unit that they were able to get economies of scale on, and they were able to grow into that without any additional capital cost up front by just increasing their reservation by 5 megawatts a year each year as we went through the contracts.
In terms of the permits, I guess that Mr. Nguyen asked about, are all those permits in the name of Big Rivers?
They are.
Are there any permits in the name of Henderson?
I'm not aware of any.
Now, the landfill that you discussed, who has legal title to the property that the landfill is on?
So Big Rivers has title to the property that the landfill is on, but the Station 2 contracts specifically state that the ash dredgings in the landfill still belong to the city of Henderson. I believe it says they're owned by the city of Henderson.
Insofar as I guess your rebuttal testimony about the difference in the residential electric rates between the city of Henderson and the 3 rural electric cooperatives that Big River serves, you indicated that in a post-hearing data request, you could provide specific information as to what those costs are or were that you claim Henderson should have be responsible for, but that Big River's paid. Is that correct?
Yes, sir.
Can you tell us, do you have some idea what those costs would be? I don't mean in amounts. The reason I ask is that I assume in a post-hearing data request, if you provide some detailed information, that counsel for Henderson might want to ask some questions about that. And I don't know, he might not, depending on what it is. But I was just thinking myself how we could do that if we don't know what those costs might be.
So I'll give you a couple just off the top of my head. One is the MISO fees, and that's part of this disputed case that we're in today. Been a lot of testimony around the MISO fees. We joined MISO. We had no choice in order to meet our NERC contingency reserve requirements. We were required to join MISO. Henderson has refused to pay any MISO fees since 2010. When we joined MISO, I think that amount is about 1.4 million roughly. We are currently being required to put a trench around the landfill, the green landfill, because when it rains, water permeates through the cover of the landfill. It runs down through the landfill, and then it runs out at the bottom of where it's piled up in the landfill, at what we call the toe. And when that water comes out, that landfill acts like a filter, except it's picking up in the water now has arsenic and might have some heavy metals or something in it. So we're required to put a trench around that landfill, capture all of that runoff water, send it to a pond to be treated before it can be released. And, as we just stated, 10% of the waste is Henderson's waste. And so 10% of that cost should go to Henderson, and they've refused to pay it. And I can go on with others, but that's the kind of things that we're discussing here. And I think some of this is actually in Mr. Smith's testimony in some of those numbers and calculations he provided.
I don't have any further questions, but Mr. Curtis, before I ask if you have any redirect, I want to ask Mr. Redding if he has any questions about this cost differential between the residential electric rates in Henderson and the 3 rural cooperatives that Big River serves, insofar as these costs are concerned.
Thank you, Commissioner. Obviously, we would need to reserve our ability, because I don't believe there's been sufficient information provided to us to properly respond to that. I guess I would have one question of clarity. Mr. Berry, at this time, it is now 2020, Big Rivers is not paying any MISO fees on behalf of Henderson at this time.
That's correct. In 2019, after the plant, Station 2 was ceased operation, Henderson joined MISO as a transmission owner and are now paying their own MISO fees, probably the same amount or more than what they refused to pay Big Rivers for.
So your answer is you're not being charged for any MISO fees on behalf of Henderson in 2020?
In 2019 and 20, we have not been. Since February of 2019, not.
Thank you.
Anything else, Mr. Reddy?
Not on I understood your directions having to on the issue of where Mr. Wynn had asked about the subsequent data request. I may have some other questions depending on what counsel for Big Rivers asked.
At this time, it's 10:30, and so we've been going for an hour and a half, and we intended to take a lunch break at noon. So why don't we take a 10-minute break at this time, Mr. Kurtz, before you conduct any redirect that you may have. So we'll be in recess until 20 minutes until 11 o'clock. Thank you. Okay, we're now back on the record. Is Big Rivers available?
Doesn't look that they are, Chairman.
We're running out of different, yeah. Okay. Mr. Kurtz, you have a redirect examination?
Yes, sir. Mr. Berry, you were asked a number of questions about the rate differential between the City of Henderson residential rates and the rates of the three owner members of Big Rivers. Do you recall that?
Yes, sir.
Is it, and part of it is, for the differential is cost that you believe the city should have paid, but Big Rivers has been paying?
That's correct.
Is another part of the rate differential reason the benefits essentially that the city has received through its contractual relationship with Big Rivers over the years?
That's correct.
Would that include use of $42 million of scrubber joint use facilities at the Green Station that was used in Station 2?
Yes, that's correct.
Would it include using the green landfill at cost?
That's correct.
Would it include providing standby capacity to the city at no charge?
That's correct.
There were a number of questions about the green landfill and the number of tons that are in there. Do you recall those?
Yes, sir.
In response to a data request from staff, 1-14, is it your understanding that at the end of 2019, the city had 2,618,667 tons of scrubber sludge and ash pond dredgings in the green landfill?
That's correct.
Okay. So your understanding their position, their position is they should no longer be required to pay for storing the 2.6 million tons in your landfill.
That's been their position, yes.
And when the green landfill is retired, their position is they should not have to pay to decommission their 2.6 million tons.
That's correct.
Staff council asked you a number of questions about the environmental rules and how they apply to different facilities at the Green Reed Station 2 complex. Do you recall that?
Yes.
Is there an exhibit that you would find helpful to talk through those issues?
Yes, it's attached to my rebuttal testimony, Exhibit 1, which is actually a map of the site, Station 2 site, and as well as the green units. We refer to this site as the Seabury site.
Thank you. Is there a way to make that a little bit bigger? Because it doesn't show everything.
Let me try, Mike. Well, let's see.
Well, we can work with that. Mr. Berry, can you go ahead and
Yeah, can you scroll down and start at the
Sure.
bottom and I'll my way up to the top? Would that work? Yeah, go on down as far as you can, please.
Okay.
Oh, there you go. Okay, so this is a good place to start. The big red circle you see on the left of the screen, outlined in red, is the green landfill. And so that kind of gives you a little bit of perspective. If you'll start scrolling back up now. If you can stop right there. So you can see the VHB switch yard to your left. That's the square you see to the left. Actually, when it's so small, it may be difficult to see. But when you look at all the equipment associated with Station 2, you can see the Station 2 ash pond is a light blue area that's encompassed to the left of the cooling tires. You can see that's the ash pond. when we talk about the property that reverts back to Big Rivers, really that's a very small piece of this whole site. So the property that has the reversion language in the deed is just those two coolant tires that you see in dark blue. And in the center there where it says H1 and H2, that's very small block, right where it says H1 and H2. So as you can see, that's the only part of the property that is covered with the reversion language. Where the ag pond's not, it's not covered. You can see bottom ash and fly ash listed there. That's not covered in the reversion deed. As you go around, you see the Reed Hempel cold storage. That's not covered in the deed. All these other conveyors that you see, I wish I had a pointer that I could show you, but all those lines that are coal conveyors, they go all the way to the river to the barge unloader, which is far right in your upper kind of right-hand corner. You see the barge unloader out in the river there. All of that is Station 2 equipment that is not in that deed. The SCR, the scrubber, the stacks. In your far right, you'll see some green, some font that's in green there. Yes, that's it. So in that area, there's also flakers and items that belong to the city of Henderson, part of Station 2. Again, that's nowhere even near that property that Henderson tries to say, well, it reverts back to Big River, so they have no responsibility for decommissioning. So what we wanted to try to represent it is this equipment is spread out over a huge area, and it's not just one little piece that has the reversion language in it. So you can see that these things are intermingled across the entire site, which is why that has been such a benefit to Henderson, why this has been such a good deal for Henderson all these years. They got to use all that property and all that equipment in that site at little to no cost. And now they're just trying to walk away and say they have no obligation for any of it. So,
Thank you, Mr. Berry. Mr. Nguyen, I think we're done with the exhibit unless you have questions.
No.
One last set of redirect. Did you recall a lot of extensive questions from council for the city about the excess Henderson energy and the release and so forth?
yes,
Okay. First of all, excess Henderson energy is the difference between, let's just make these, if they reserved 115 megawatts and their actual load was 100, that would mean there was 15 megawatts of excess Henderson energy for that particular hour. Is that correct?
that's correct.
And for that particular hour, the revenues that could be received in the MISO market might be higher or lower than the cost of Station 2. Is that correct?
That's correct.
So for example, in July, the excess Henderson energy might be profitable or wanted, but in May, it may be unprofitable or unwanted.
That's correct. And it can change by hour, not just by month.
And it's your position that the release covered all excess Henderson energy, not just a subset.
That's correct. I specifically demanded that language that's in the contract, in the settlement agreement to be there, because I wanted it to cover all excess Henderson energy so that there's no more litigation. There's been litigation for 20 years over excess Henderson energy between LG&E and Big Rivers paid twice to resolve those issues, and I just wanted to resolve it once and for all.
I want to just read you the release. It's a little bit lengthy, and then I just want to ask you a question on it. This is attached to Mr. Berry's direct testimony as Exhibit 1. This is the release that was referred to in the cross-examination. In consideration of the mutual promises, covenants, and agreements contained in this agreement, the resolution and settlement of disputed claims and controversies, and other good and valuable consideration, the receipt and sufficiency of which are conclusively acknowledged, Henderson hereby releases, acquits, and forever discharges individually and collectively Big Rivers and WKE, that's LG&E's unregulated affiliate, is that correct?
That's correct.
Okay. Along with their affiliates, parents, members, officers, directors, employees, agents, representatives, advisors, successors, predecessors, boards, and assigns, collectively the released parties, of and from any and all manner of actions, causes of actions, suits, sums of money, accountings, reckonings, covenants, controversies, agreements, promises, remedies, amount paid in settlement, compromises, losses, rights of contribution, damages, judgments, execution, debts, obligations, liabilities, claims, and demands of any nature or kind whatsoever, whether or not in contract, equity, in tort, or otherwise, which Henderson ever had, now has, may now have, or may hereafter have, against the released parties or any of them, resulting from, arising out of, or in any manner relating to the generation, production, use, sale, or resale of disputed excess energy as defined herein, or the capacity, fixed or variable costs associated with such energy, including but not limited to those asserted or that could have been asserted in, or that were or could have been in any way connected with the damages suits or the arbitration proceeding, and any obligations, past or future, of Big Rivers to Henderson under the power sales contract or the arbitration proceeding related to, arising out of or concerning disputed excess energy as defined herein, whether known or unknown, accrued or unaccrued, asserted or unasserted, direct or indirect, fixed, contingent, or otherwise, collectively referred to as the released claims. One, just a little bit more. Henderson acknowledges that it may hereafter discover claims or facts, in addition to or different from those currently known to Henderson, with respect to the release and the released claims. Henderson hereby expressly assumes the risk of any mistake of fact, and of any facts proven to be other than or different from the facts now known to any of the parties or believed by them to exist. Henderson intends to fully, finally, and forever settle and release all released claims, and in furtherance of such intention, this release shall be and remain in effect as a full and complete general release with respect to the released claims, notwithstanding the discovery or existence of any such additional or different claims or facts, end quote. When you paid the city of Henderson $6.25 million, was it your understanding that this release forever resolves the excess Henderson Energy, all claims before January 4th, 2018?
Yes.
Mr. Chairman, no more questions?
Thank you. Now, that normally would end the examination of Mr. Berry. But, Mr. Redding, I want to give you one more opportunity, if you choose to cross-examine Mr. Berry only on the costs which he says, or which Big Rivers say, contributed to the higher utility rates, electricity rates for residential customers among his three rural electric cooperatives as opposed to the city of Henderson. In order to solve the issue about additional information from a data request, I'm going to direct staff counsel not to send a data request asking for this specific information. Big Rivers chose not to provide detailed information in the first place, and so there's no need for us to have that in any way to resolve this matter. So, Mr. Redding, would you like to ask Mr. Berry additional questions limited to those costs that he discussed on redirect as bearing on the difference in electricity rates?
No, Mr. Chairman.
Okay, thank you. All right, may this witness be excused? Mr. Redding,
Yes, Your Honor.
you may step down, Mr. Berry. Thank you.
Thank you.
Okay, Mr. Kurtz or Mr. Kamuth, please call your next witness.
Thank you, Your Honor. We would like to call Jeff Kopp. He's remote. He's the Burns McDonald witness.
Thank you. Now,
Yes.
he's a remote witness, is that correct?
He is a direct and rebuttal witness.
Okay.
Who was that?
Oh, remote.
Chairman?
Yes, he's
I'm
remote.
sorry,
What was the name of the witness?
Jeffrey Kopp.
Kopp, Mr. Kopp.
Mr. Cobb. Thank you.
Hey, Mr. Kopp, is that you?
Yes, good morning.
Would you please raise your right hand? Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Mr. Kurtz, you may ask.
We say your name and business record, business title for the record.
Yes, my name is Jeffrey T. Kopp, I go by Jeff. I'm the manager of our utility consulting department in our 1898 and Co. division of Burns and McDonald Engineering Company.
Did you cause to be filed direct and rebuttal testimony?
Yes, I did.
Was it prepared by you or under your direct supervision?
Yes, it was.
Or to ask you the same questions as those contained therein, would your answers be the same?
Yes, they would.
Any corrections or additions you'd like to make?
One minor correction, in my testimony, I was listed as working in the Business and Technology Solutions Division, and we have renamed that division to 1898 and Co.
Chairman, we tender the witness for cross-examination.
Thank you. Mr. Redding, cross-examination.
Randall Redding for Henderson Municipal Fire and Light. You're not offering any testimony as to the fee simple or title ownership to the Station 2 plant or the cooling towers, are you?
I am not.
That's all.
Okay, thank you. Mr. Nguyen, questions?
No questions, Your Honor.
Commissioner Matthews, questions?
I don't have any questions.
I have none either, so may Mr. Kopp be excused?
Yes, sir.
I assume that you're excused, Mr. Kopp. You probably got the benefit of being the shortest witness that we've ever
Wow.
had here before the Public Service Commission, so thank you.
All right, thank you.
You're excused. Mr. Kurtz, you care to call another witness?
Yes, sir. We call Michael Pullen.
Please raise your right hand. Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Mr. Kurtz, you may ask.
Will you state your name and business address or business title for the record, please?
It's Michael T. Pullen, Executive Vice President Operations for Big Rivers Electric.
Did you file direct and rebuttal testimony in this case?
I did.
If I were to ask you the same questions as those contained therein, would your answer be the same?
I do have some changes.
Okay.
Okay, so first off, regarding the grain landfill cost sharing percentages that Mr. Redding asked Mr. Berry about earlier, discussing my testimony on page 18 of 23, and in the data response to Hempel 1-63, I'd like to make a change. At the time, my testimony and data response was based on the actual quantities of material that were stored in the green landfill on a monthly basis for the time period from 1995 to 2019. And this is based on actual data reported monthly, known to both parties. This week, at Hempel's request, they requested that Big Rivers estimate the amount of ash placed in the landfill prior to 1995, for which there is no data, but we are able to make some engineering calculations. To do that, I use the annual generation for each of the units at the Sebree Station, Green 1, Green 2, Reed 1, Station 2, Units 1 and 2. I use the ash content for the fuel characteristics for the years that were available
For some of those years, the fuel characteristics was not available, so I substituted data from surrounding years, making the best estimate possible at the time. I assumed that all the fly ash and bottom ash from Reed 1, Station 2, and Green was placed in the landfill. So given all that, the calculations yielded the following changes. Henderson's share of ash that's currently stored in the Green landfill, we would calculate that to be 9.88% as opposed to 11.25% previously measured based on actual data. So there is some change, 9.88 compared to 11.25.
Can I stop you, Mr. Pullen? Is there a tonnage amount associated with 9.88%?
Yes. It's 2.853 million tons. But that's the city share.
Sorry, thank you. Continue.
We also, in my direct testament, only on page 18 of 23, lines 10 through 11, I indicated that we did not have closure costs estimated for the Green landfill. We have those costs today, estimated costs. It's based on a closure turf system, a synthetic system. Same system as we have planned for Wilson and was discussed in the environmental compliance plan recently approved by the commission for the phase 1 closure of the Wilson landfill. The least cost estimate solution is $20.7 million for closure of the Green landfill. We're now able to make a estimate because, as Mr. Berry earlier testified, we have a forecast end date for generation for the Green units of June of 22. Henderson's share of that is estimated to be approximately $2 million based on the roughly 10% share of your waste in the landfill. And finally, the last change that I need to submit is regarding the Green Title V permit, was discussed in my rebuttal testimony on page 5, lines 15 through 18. The Green Title V permit was revised by the Kentucky Energy and Environment Cabinet on September 17th, 2020. The statement quoted in my rebuttal testimony from the executive summary was replaced with the following. It says now on February 1st, 2019, the Henderson Station 2 ceased operation. Those are the only changes I have.
Thank you, Mr. Pullen. Your Honor, the witness is ready for cross.
Okay. Mr. Redding, cross-examination?
Yes, Mr. Commissioner. Mr. Pullum, the statement that you amended on the green permitting was changed from a statement that Big Rivers had committed in there that the city of Henderson was the owner and operator of Station 2, correct?
That was not Big River's statement. That was the Energy and Environment Cabinet's statement. They're the ones that issued the permit. But we agreed to the change as it currently reads.
Because we recognize that the ownership of the Station 2 and the cooling towers under a legal pending lawsuit is in dispute.
I'm aware there is a lawsuit in Webster County related to the reversion deed of Station 2 and some of the property that's owned by Station 2 by the city of Henderson.
You gave Mr. Kurtz the denominator of what you estimated to believe the tonnage. What would the denominator be in your? So if you gave the numerator, the denominator be?
Yeah, I gave the numerator for the city share, which is $2.853 million or tons. The denominator for all the ash that's in Station 2 in the Green landfill is 28.862 million tons.
And that number, Big Rivers is continuing to use the its greenfield asset, is it not?
Yes, we continue to use it.
Continue to put green station waste in that landfill.
Yes.
And so the the lower number will continue to increase in this formula.
That is correct. Yes, the 9.88 reflects the percentage of ash that the city of Henderson owns in that landfill as of the end of 2019. It's Big River's position that as we incur costs to do maintenance related to the storage of that ash on an annual basis, the city should be responsible to pay their share of that storage as those costs are incurred based on the percentage of ash on an annual basis. So that's the percentage we know today for expenses incurred related to the storage of ash in 2020. We will update that number at the end of 2020, and then if we incur expenses related to the storage of the city's ash in 2021, that percentage will go down because the denominator goes up, as you explained.
There will be no more Station 2, irregardless of the percentages going into the land. There is no more after February of 2019.
Well, so we have not done the engineering, neither party's done the engineering to close that Station 2 ash pond. There still is bottom ash in the Station 2 ash pond that's from Station 2. Depending on the final closure and the groundwater monitoring that's going to go on for 30 years, if there's an impact to groundwater monitoring, there's a potential that bottom ash in the ash pond might eventually have to be removed from the ash pond. That might get put in the station, in the green landfill, and that would change the city's percentage.
But as we sit here with the proceedings today, since February of 2019, there's not been any Station 2 waste going into the Big River's green landfill asset.
We haven't put any in, yes, since the plant was shut down, there's not been any more put in there.
And Big River's charged Henderson a disposal fee up through 2019 for the waste coming out of the Station 2, did it not?
So what we did was, we have a third-party contractor that hauls the waste from the dewatering location at Green. It hauls that ash to the landfill. They place it in there, they maintain it, and operate that for us. So as Big River's incurred those costs, we pass those costs, as we incurred those, the exact cost to the city. We did not make any profit. We didn't charge any administrative fee. There's no profit at all. It's just we passed the cost to the city as we incurred those costs from the third-party contractor.
And the city of Henderson paid those costs to Big River, paid those bills.
Yeah, to the extent that, well, I hesitate to say if they've been paid because it's my understanding that as part of this proceeding, there's still outstanding payments due related to some of the fiscal years. And Mr. Smith probably can answer that better than I can.
To your knowledge, though, any bill that was presented for the disposal was paid.
It was paid by Big Rivers, and it would have been accrued as part of the annual fiscal year settlement against the budget payments that were made by the city.
Thank you, Seth. May I have just a minute?
Yes, you may.
Can we move that? David, you know how to use that. That's all I have, Commissioner.
Thank you. Mr. Nguyen, questions?
Yes, Your Honor. Good Good morning, Mr. Poland. Can you hear me okay?
Yes, I can.
Okay, great. Can you refer to your rebuttal testimony on page 5? This is regarding the new Title V operating permit for the Green Station.
Okay.
So the new permit was issued on July 12th, 2020, correct?
Well, but in my rebuttal correction, it was reissued on September 17th, 2020.
Okay, that's correct. So what precipitated Big Rivers to try to obtain a new air permit for the Green Station?
So Big Rivers did not ask for a revision. The city of Henderson requested a hearing on the Green Title V permit after it was issued, and that precipitated this change that was made.
Okay. And you mentioned that in the executive summary, the language regarding the ownership of Station 2 being solely being the city of Henderson, as well as being the sole operator of Station 2. And you mentioned that that language was included by the Division of Air Quality and not by Big Rivers?
Yes, that was in the permit as issued by the Kentucky Division of Air Quality.
Okay. If you know, would you have any knowledge as to why that was included in by DAQ?
So when Station 2 was retired, prior to its retirement, Big Rivers and the city of Henderson sent a joint letter to the Division of Air Quality indicating that the Station 2 was going to be retired on February 1st and would no longer be in operation. Subsequent to that, they issued this statement in the permit based on that letter and their understanding of it. I think based on their understanding of the operation of Station 2 going forward, that Big Rivers was no longer the operator of Station 2 once the contracts between the city and Big Rivers had expired.
Okay. Does Station 2 have a Title V operating permit, or did it have a Title V operating permit as well?
It did.
Okay. And I take it that's no longer in effect?
It's, what's in process now is a revision to the permit to include a recombustion turbine. But the Station 2 units will no longer be on the operating air permit.
Do you know if there's any similar language in the Station 2 air permit regarding the city's ownership or an operation of Station 2?
There is not, because that permit precedes the retirement of Station 2, and it has not been reissued yet.
Okay. Not sure if it's been provided, but could you provide a copy of the Green Station Title V permit?
I will.
Okay. And would you also have access to the Station 2 Title V permit? Or
Yes,
Big
we do.
Rivers? Okay. Could you request that to be provided as well?
I will.
Okay. Can you turn now to page 6 of your rebuttal?
Okay,
It's at the top of the page regarding the city of Henderson now being responsible for environmental compliance at Station 2 as a result of the new Title V operating permit for the Green Station. So you mentioned that you had written a letter to Ms. Heimgartner indicating that as well. So in addition to the letter that was written to Mr. Heimgartner and the new Title V air permit for the Green Station, are there any other steps that need to be taken to effectuate the shifting of the environmental compliance responsibility at Station 2 from Big Rivers to the city of Henderson?
the KPDS permit needs to be revised to shift responsibility for the Station 2 ash pond, to make it clear the city's the operator of the Station 2 ash pond and the associated outfalls.
And who's responsible for making that change? Which, the Big Rivers or the city?
So Big Rivers has submitted an application to make that change, but to have the change completed, the Kentucky Division of Water has indicated that the city must agree to accept that responsibility. And as of yet, the city has not agreed to accept the responsibility as the operator for the Station 2 ash pond and associated outfalls.
Okay. Any other steps that need to be taken?
Not that I can think of at this time.
Okay. So what would happen if the city does not accept responsibility to take over the compliance, environmental compliance responsibility with respect to the Station 2 ash pond?
So those responsibilities or those regulations fall under the Kentucky Division of Waste Management, Chapter 45 and Chapter 46 regulations. So could be subject to notice of violation and enforcement action by the state, as well as the ash pond closure is regulated under the federal CCR regulation, which is enforceable through civil action.
Well, I was asking more in terms of the change that's been requested by Big Rivers with respect to the permit related to Station 2, to have the city assume responsibility for compliance with respect to the Station 2 ash pond. And you mentioned that the city at this time has not yet agreed to accept responsibility. Is that correct?
That is correct.
Okay, so to the extent that if the city doesn't agree to accept responsibility, what happens to that permit? Or that request to revise the permit?
I probably would need to refer that to our council, but I believe Big Rivers would be required to take some sort of legal suit to compel the city to take on that responsibility.
Okay. And short of having to make that, needing to make that change, would Big River still be responsible for the compliance, environmental compliance with respect to the Station 2 ash pond, and therefore any penalties that may result from any non-compliance?
So Big Rivers, as the operator on the KPDS permit, we're continuing to comply with those requirements because as the operator on that, we are liable for that. For the ash pond closure, those regulations apply to the owner and the operator. So the city is the owner and operator of the ash pond itself. So that in our position, that liability lies with the city.
Okay. So the change in the permit for Station 2, the operation of the Station 2 ash pond would not impact who's would be obligated, which entity would be obligated for any non-compliance penalties. Is that what you're saying? Well, let me restate that. The requested change in the permit for the Station 2 ash pond, to the extent that the city does not accept responsibility does not accept responsibility for that change. Any future potential non-compliance with the CCR rule, the penalties associated with any of those non-compliance would then be obligated to the owner, which would be the city. Is that correct?
Yeah, the CCR rule applies to the owner and the operator. The city is clearly the owner of Station 2. Big River's responsibility as the operator ended at the end of the Station 2 contracts when they terminated in 2019. So by default, as the owner, the city is the operator of the Station 2 ash pond as well. Big Rivers is the operator on the KPDS permit, which includes the Station 2 ash pond. So there is, I guess, some ambiguity there. And it'd be a concern on ours that we could potentially be responsible for enforcement action if this doesn't get resolved properly and clearly.
Okay. Can you look down on lines 8 through 11 of your, on the same page, page 6 of your rebuttal testimony? You discussed the recent filing by the City of Henderson and Webster Circuit Court regarding the decommissioning costs of the Station 2 ash pond.
Okay.
Does Big Rivers have a copy of that complaint?
Yes. Yes, we do.
Could I request a copy of that complaint as part of a post-hearing data request?
Okay. That's the May 2020 complaint in the Webster Circuit Court.
Regarding the decommission cost allocation between the city and Big Rivers.
For the Station 2 ash pond, yes.
Could you turn to page 7 of your rebuttal testimony now?
Okay.
And lines 12 through 14.
Okay.
Similar question was asked of Mr. Berry, but you also provided the same type of statement in terms of to the fact that Big Rivers would have no contractual obligations to share in any retirement in place costs associated with the decommissioning of Station 2. Could you provide some additional details or support for this particular statement?
Yes, so the 1993 amendments provided that Big Rivers would share in the decommissioning of Station 2 if Big Rivers chose to extend the contracts for the life of the plant. Prior to that, Big Rivers did not have an obligation to pay for decommissioning of Station 2 in the contracts. Of course, the contracts were extended through the life of the plant. So we have decommissioning responsibility of approximately 78%, but we do not have responsibility to pay for the units to sit in a retired in place situation indefinitely. The contract language clearly addresses decommissioning, not retirement in place.
Okay, so so your position is that the term decommissioning, as it's mentioned in in the Station 2 contracts refers only to the full retirement, the complete demolition and remediation of the facilities, and not a retirement in place scenario?
Yes, that's what we believe the decommissioning was meant to be, would be to the final retirement and disposition of the units to bring them back to a brownfield state. As we've said in our testimony that Mr. Kopp and I have as well, after about 5 to 7 years, you're going to spend as much money keeping a unit in a retired in place condition is what it would to eventually dismantle the unit and do that. And, you know, common sense tells us you can't leave those units, those structures standing there forever. They're going to deteriorate. They're next to other operating units. The Reed combustion turbines, it's directly adjacent to the Station 2 units. You know, based on our experience at Coleman, we know that as time goes on, structures deteriorate, and it just doesn't make sense to leave a unit indefinitely like that. Eventually, it's going to have to come down. So Big Rivers doesn't understand, or we don't think we're responsible for leaving the unit just sitting there and retired in place indefinitely. We're fully prepared to pay our 78% of decommissioning and dismantling the units and returning them to the brownfield condition.
But is it ultimately the city's decision with respect to that?
It is. They're the owner.
And you mentioned the 5 to 7 years range with respect to retirement in place costs outstripping the cost to fully retire the station. Was that 5 to 7 years range based upon the original estimated cost to fully decommission Station 2, and not based upon I would say that the cost that was mentioned earlier by Mr. Berry, which was much less?
Yeah, so just let's talk about kind of numbers that Big Rivers knows. We spent to keep Coleman idled, which are similar units. There's 3 units at Coleman, 2 at Station 2, but they're essentially the same units. We spent in the range of $1 million a year initially to keep it idled, similar to a dry, dark, and safe condition at Station 2. Now that cost did go down over the years. We now know, based on the bids that we've gotten to dismantle the Coleman units, that's $3 to $6 million. So, you know, I think based on the information that I have today from Coleman and its applicability to Station 2, I think 5 to 7 year payback seems like a reasonable estimate to me.
Okay. And you mentioned that the annual costs associated with idling the station versus the annual cost to keep it in a dry, safe, and dark situation is roughly the same. Is that correct?
Yeah, to keep it idle is more expensive because we had dehumidifiers on the units at Coleman because we anticipated restarting that. So we had more people on site doing testing, rotating equipment, maintaining those dehumidifiers. But I would also point that you go back and look at the city's IRP, I believe they did in 2017. Their consultant estimated $775,000 a year to keep the unit in a retired in place condition. So, you know, it's in the ballpark of what we saw at Coleman.
Okay. Those are all the questions I have. Thank you.
Mr. Matthews, questions?
I don't have any questions.
Neither do I. Mr. Kurtz, redirect.
Yes, sir, thank you. Mr. Cullen, compliance with the CCR rule at the Station 2 ash pond is a legal requirement, correct?
Yes.
And what is your best estimate of the cost to close decommission the Station 2 ash pond consistent with the CCR rule.
So the total cost is estimated at $13.3 million.
It's correct, isn't it, that the ash pond is included in the definition of Station 2? The ash pond is part of Station 2, just like the boilers and chimneys and the turbines, et cetera. So if the decommissioning cost percentage applied to the ash pond, the city share would be approximately $3 million.
Yes.
In order to comply with federal law and to avoid these civil and criminal penalties which could arise as to somebody, is Big Rivers prepared to decommission the Station 2 ash pond, provided that the city pays its 22.76% of the decommissioning costs?
Yes, we've gotten authority from the PSC to spend that money to decommission it. We've got proposals from engineering companies to do the final engineering design for the closure. We just need to have the agreement from the city on we're going to each pay our share, and we're prepared to move forward.
Mr. Chairman, no further questions?
May this witness be excused?
Yes, Your Honor.
I assume that you may step down.
Mr. Chairman, may I ask a question?
Well, you want to ask a question of the witness?
Yes, Your Honor. Yes, sir.
All right. Normally I'd say no, but let's go ahead and ask a question.
I don't think these are relatively. Mr. Fulham, as a follow-up to what Mr. Nguyen has asked you, can you also provide in your supplemental data request regarding the application for the green permit, the filings that Big Rivers filed for the application addressing the air quality green permit that Mr. Nguyen asked you to address?
So Mr. Glenn, I assume we're going to get it in writing. What I understand, he didn't ask for the application. He asked for the permit as issued on September 17th of 2020.
That's correct.
So you're going to provide the information of which the cabinet relied upon for their statement that we talked about?
No, he asked for the permit as issued. It's a public document, but we're happy to provide it.
Can you provide the application that Big Rivers sent to the cabinet?
We have an application. We can provide it, yes.
Did you say you would?
Yes.
And the ash pond is a joint use facility asset?
It's a city-owned joint use facility, yes.
Thank you, sir.
Is that all you have, Mr. Redding?
Yes, sir.
So you'll need to, at the close of all the testimony, the parties will discuss the time needed to draft and respond to these data requests, which are really just interrogatories. So you'll need to, at some point, we'll talk about, you'll need to file a data request into the record and serve it upon Big Rivers in order to get that information. I will also say this. This is a contested proceeding between two parties, and so data requests, including data requests from staff, are going to be limited to documents such as permits and other things other than evidence. We're not going to entertain any additional evidence or explanation by way of a data request because it deprives the other party, whichever party it is, of an opportunity to cross-examine or basically to contest it. So the data request will be limited to documents. All right, Mr. Kurtz, you have another witness?
Yes, we do. Chambliss?
Will you please raise your right hand? Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. Mr. Kurtz?
Will you state your name and business address for the record, please?
My name is Michael W. Chambliss. My business address is 201 3rd Street, Henderson, Kentucky, 42420.
And your title?
Vice President of System Operations for Big Rivers Electric.
Did you prepare direct and rebuttal testimony in this case?
Yes, I,
If I were to ask you the same questions, would your answers be the same?
yes, they will.
Any corrections or additions?
No, sir.
Your Honor, the witness is ready for cross.
Okay, Mr. Redding, cross-examination.
We have no questions of this witness.
Mr. Nguyen, questions?
Just one quick question, Your Honor, more of a clarification than anything else. Good morning, Mr. Chambliss.
Good morning.
Could you refer to page 3 of your rebuttal testimony? The response at the bottom of the page, lines 15 through 19.
All right, page 3, lines 15 through 19, is that correct?
Yes, sir. The response, well, the question at, above this response refers to the direct testimony of Mr. Bickett regarding the power sales contract and the systems reserves agreement being entered into prior to joining MISO, and that neither of those amendments were amended to address a transition to MISO. And then your response to the question of whether or not you agree with Mr. Bickett's statement was no. And you mentioned that the system reserves amendment was amended in 1998 to specifically address RTO such as MISO. Is that correct?
Yes, sir.
Okay, and then you also say that since the system reserve agreement already had a provision to recognize a RTO such as MISO, it required no additional amendment, as Mr. Bickett implies. Is that second reference to the system reserves agreement, was that meant to be reference to the power sales agreement?
No, sir, it was the Systems Reserves Agreement as it was amended in 1998.
Okay, okay. And what about the power sales agreement? Did that already contain language regarding the recognition of a RTO such as MISO in the power sales agreement?
I apologize, I don't have sufficient knowledge to answer that question.
Okay, okay. Those are all the questions I have. Thank you, Your Honor.
Commissioner Matthews, questions?
I don't have any, thanks.
I have no questions. Mr. Kurtz, any redirect?
Very, very briefly, Mr. Chambliss, staff counsel Wynn asked you about the system reserves agreement and its anticipation of MISO, essentially. Is this the provision, page 10 of the 1998 amendments?
Yes, sir, it is. Section 2.1 on page 10 was amended in 1998. Originally, Section 2.1 addressed specifically planning reserve margin. In 1998, 2.1, the scope of what that addressed was significantly expanded to cover not only planning reserves, but all reserves on the system. And specifically, any regional transmission authority was placed in Section 2.1.
Would that include MISO?
Yes, of course, whenever this was negotiated or added, LG&E
was a party to the original amendment. LG&E was one of the founding transmission owners in the MISO. So MISO was being stood up in that time frame, and so LG&E was aware well of that and addressed that with this language of regional transmission authority.
Mr. Chairman, no additional questions.
May this witness be excused? Mr. Chambliss, you may be excused. Thank you.
Thank you, Your Honor.
It's, I guess it's 20 minutes till noon. Mr. Kurtz, is there a short witness that you think we may, I guess that depends on Mr. Reddick more than anything else. But,
We have
let's see if
two.
we can call and get another one started anyway.
Would you like us to do that?
Yeah, let's put on, try to get one more witness.
Okay. Mr. Akrit?
Who did you say?
Mark Ekert.
Secret.
Mr. Ekert, would you please raise your right hand? Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Mr. Kurtz, you may ask.
Would you state your name and business address for the record, please?
Mark Akert, 201 3rd Street, Henderson, Kentucky.
Did you prepare direct and rebuttal testimony?
Yes.
If I were to ask you the same questions, would your answer be the same?
Yes.
Any corrections or additions?
No.
Your Honor, the witness is ready for cross.
Okay, Mr. Redding?
We have no questions of this witness.
Mr. Nguyen, questions?
Just one question, Your Honor. Good morning, Mr. Ekert.
Mark.
In the financial disputes portion of this case, Big Rivers is also requesting interest in addition to the cost that it says that it is entitled to from the city of Henderson. Is that correct?
Yes.
Okay. And there's a statement in your rebuttal testimony at page 9 of 12 regarding specifically interest on the MISO fees. And you state that interest is needed to make Big Rivers whole. Do you recall making that statement in your rebuttal testimony?
Yes.
Okay. Can you explain why interest is needed in order to make Big Rivers whole?
Our members have been bearing costs directly attributable to Henderson load and transmission for 6+ years, and bearing the carrying costs of those expenses. And so it seems equitable that our members should be compensated for that.
Okay. Those are all the questions I have.
Commissioner Matthews? Commissioner Matthews, any questions?
Sorry, you would think I would figure out the mute button by now. I do not have any, thank you.
I have no questions. Mr. Kurtz, redirect.
No redirect.
May this witness be excused? I assume so. You may step down, sir.
Thank you.
Now, Mr. Redding, I'm going to leave it up to you, since it's your cross-examination. I don't know how long your cross will be. There's one more witness, is that correct, Mr. Kurtz?
Yes.
And is that Mr. Smith?
Yes, sir.
And I'm always hesitant to interrupt an examination or a cross-examination to break for lunch, but we're going to do that at noon. So if, Mr. Redding, if you tell me you have a short cross, we'll go ahead and complete this witness. If you think it may take some time or take more than 15 or 20 minutes, we probably ought to just go ahead and break for lunch. If we finish with this witness, then you'll be putting on proof, I guess, at 1 o'clock.
I'm not anticipating any questions of Mr. Smith.
All right. Okay, then, let's go ahead and put Mr. Smith, get Mr. Smith's testimony. Okay, Mr. Smith, please raise your right hand. Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may ask.
Will you please state your name and business address for the record, please?
Yes, my name is Paul Smith. My business address is 201 3rd Street, Henderson, Kentucky, 42420.
And your title?
I am the Chief Financial Officer for Big Rivers.
Did you prepare direct and rebuttal testimony?
I did.
Do you have any corrections or additions you'd like to make to your testimony?
I do.
Please.
First, a correction. It was mentioned previously by Mr. Barry and Mr. Poland about a change in the Hempel allocation of the landfill to 9.88%. I have not done the calculation, but that would impact the amount owed by Hempel as of June 30th, 2020, by approximately $80,000. I also have two typographical corrections. First, to my direct testimony, page 6 of 19, on line 7, reference to the previous case that's been discussed this morning. That case number on line 7, it says it's 2018-00. The actual case number was 2016-00278. One other typographical correction on my rebuttal testimony, page 29 of 30, line 8. The first word on that line is refuses. The R was missing. It says efuses. So the sentence should read, beginning on line 8, if Henderson refuses to comply with the commission's lawful order by not paying its invoice for its share of Station 2 costs, then the commission should seek to compel obedience to its rate order at the Franklin Circuit Court pursuant to KRS 278.390. That's exactly.
Chairman Schmidt, would you prefer or would you entertain an amended schedule from Mr. Smith showing that $80,000 correction?
That correction works to the advantage of Henderson, is that correct?
That's correct.
Yes. Yeah, unless Mr. Reddick, I assume, wouldn't object. So if he does, we're going to go ahead and let you put it in anyway, if you go ahead and file that. Post hearing, I suppose, is that you would are you prepared to file something now or after the case is after we finish the testimony?
I think after the case, I don't think it's prepared now, or is it?
It's not yet available, but can be shortly.
When you say shortly, what do you mean shortly? Today?
Within a day, certainly within a day.
That just file. Well, you can just file it. We'll take it up at the end, but you can file it as because we'll have a briefing schedule and data requests, so that'll be fine. You can file it along with the data requests if you'd like your responses. Mr. Redding, you have a cross-examination of this witness?
Just briefly, Mr. Randall Redding for Hempel, Mr. Smith, your calculations as presented in your direct and rebuttal testimony are based upon Big River's position in this case, are they not?
They're based on Big River's books and records, which reflect all documents available to Big Rivers and our interpretation thereof, yes.
It's based upon your interpretation. You understand that Henderson has a different interpretation that would drastically change the calculation.
Many different interpretations, yes, I'm aware.
And in your testimony, you asked the commission in relation to your calculations to not look back prior to January the 5th of 2018 in relation to your calculations.
I think to say differently, I would say that issues regarding excess Henderson energy and the totality of the excess Henderson energy was resolved in the December 2017 settlement agreement,
and therefore there are no amounts prior to January 4th, 2018 that are relevant or payable by either party.
My question to you though, in your file testimony, on rebuttal testimony, page 3 of 30, you're asking the commission to not reach back to the time period prior to January 5th of 2018 in regards to my calculations.
That is correct.
All right. And the Franklin Circuit Court, if you know this, Big Rivers has also asked the Franklin Circuit Court to assess variable cost damages to Henderson in an amount of approximately $10 million. Are you aware of that?
I have no familiarity with that.
But by not looking back prior to 2018, in exchange for what Mr. Berry said was 6.25 that Eon paid, Big Rivers would keep $10 million in revenue for uneconomic excess energy. They would keep $2 million for profitable energy, and they would be reimbursed their variable costs for that energy that would be then pushed off to Henderson, correct?
No, I would probably disagree with all three of those.
Under your scenario, well, let's go through it again. Under the scenario that you are representing, if the Franklin Circuit Court awards variable costs to Henderson in the amount of $10 million, they would be paid to Big Rivers, correct?
Again, I'm not familiar with that. If the court so approved it, then we would certainly feel obligated, but I'm not familiar with that calculation.
And you do know that the revenue you receive from the disputed energy, for the unwanted, unprofitable energy from June of 16 to 2017, the revenue under your data request, page 101, witness response, was $10.69 million.
Yeah, we would need to be careful with mixing revenues with expenses. So there was approximately $10 million of revenue. There was also an offset of about $8 million of Big Rivers costs, and neither of those amounts would include the Henderson variable costs. So in total, I think the total expenses probably or likely did exceed the $10 million. But roughly, Big Rivers variable costs exceeded $8 million.
And the reason is because Big Rivers used Henderson's coal, so not only would Henderson have to pay the variable cost against this unprofitable $10 million, they'd have to write off their coal.
I would disagree. They had used Henderson's coal to the extent that it existed, but there was not sufficient coal to generate all of that excess Henderson in totality. So thus, the Big Rivers coal was used for both excess Henderson energy and the native load to serve the citizens of Henderson. So I would say it was by both parties.
But during that time period, Big Rivers used all of Henderson's coal and lime that was available.
If there was any available, the excess Henderson energy that was generated for the benefit of the city of Henderson used Henderson coal, as it correctly should.
And when you reference the unwanted Henderson energy, that is energy that the variable cost exceeded the revenues that it could generate.
So where did I reference unwanted energy? I don't remember that reference either in my testimony or...
Well, let's not look for it. Do you understand and agree with me that the unwanted energy is that energy that it costs more to produce than you can get revenues for?
Well, just a recollection, the city of Henderson required that Station 2 continue to operate when it was uneconomic. And again, I would call it a common utility practice of economic dispatch that the unit should not have generated it. So the fact that Henderson wanted Station 2 to generate that energy, I don't know that I would call it unwanted because the city of Henderson wanted it, obviously.
Well, let's redefine it. Let's start over again. Would you agree that uneconomic excess energy, uneconomic energy is that energy that it costs more to produce than you can receive revenues for?
That would be uneconomic. I would agree with that.
Thank you. That's all we have.
Mr. Nguyen, questions?
Yes, Your Honor, thank you. Good morning, Mr. Smith. Just a couple of questions. Can you refer to your rebuttal testimony, page 8? And specifically lines 9 through 12, where you address Ms. Mall's testimony, particularly Exhibit Mall-2. Do you see that?
Yes.
Okay.
I
You state that Exhibit Mall-2 didn't set forth amounts that related solely to the excess Henderson energy, but also included fuel and reagents provided by Big Rivers to generate the energy needed to serve Henderson's native load. From the Exhibit Mall-2, could you provide a breakout of the amount of fuel and reagents that were used to serve Henderson's native load, and those amounts related to the excess Henderson energy? And I guess, is that shown by chance in your Exhibit Smith-3 to your direct testimony?
You're exactly correct. Smith Exhibit 3 is the native load component.
Okay.
That Moll's exhibit, which I believe is only a partial reproduction of that page that was attached to a settlement agreement by Mr. Berry. But it's only a partial representation. But that data is contained in the native load component is contained in my Smith Exhibit 3. That's correct.
So if we take your Exhibit Smith-3 and net that from the Exhibit Mall-2, we'll have the fuel and reagents associated with the excess Henderson energy?
That's correct. And then subtracting what is in Smith Exhibit 2, then we give you the piece prior to January of 2018.
Okay. Thank you for that clarification. And also turn to your rebuttal testimony, beginning at the bottom of page 11, regarding the Green Station landfill expansion. You address Ms. Mall's testimony regarding the city's lack of awareness of that plan. And you mentioned at the top of page 12 that that you had knowledge that Henderson employees, Mr. Wayne Thompson, Mr. Gary Quick, and Mr. Ken Brooks were all very familiar with that green landfill expansion project. Is that correct?
Yes, that's correct.
Okay. Do you know what positions or what titles, what job titles these three individuals held at Henderson?
I do not, but I believe Mr. Thompson and Mr. Quick were, Mr. Quick was general manager. I believe Mr. Thompson and Mr. Brooks may have had similar production-related job responsibilities at Hempel. So they would have had hands-on knowledge of what was happening at Station 2 in the Seagree facility. I'm not sure the financial group necessarily had that.
Okay. And how did you know that these individuals were very familiar with the landfill expansion project at the Green Station?
We had a conversation. I was aware that Henderson, when the vertical wall, expansion wall was being contemplated, had talked about the remaining useful life of Station 2. And at that time, they were estimating many, many years remaining in Station 2 of useful life of Station 2. And therefore, there was a need to expand the green landfill. And based on their assertions of how long Station 2 would continue to operate, that was why we needed to vertical wall expansion, or the least economic alternative to store the ash and the residuals.
So was this close, and was their knowledge of the expansion project close in time to when the project was actually implemented?
Absolutely.
Okay.
Yep. Mr. Thompson was, I think, only employed until about that point in time.
Okay. Those are all the questions I have. Thank you, Your Honor.
Commissioner Matthews, questions?
I don't have any.
I have none. Mr. Kurtz, redirect.
No redirect.
All right, may this witness be excused? All right, you may be excused, Mr. Smith. Mr. Kurtz, do you have other witnesses, or is this the case for Big Rivers?
Mr. Chairman, that's Big River's case.
All right, let's take a lunch break until 1 o'clock, and when we come back, Mr. Redding, will you be ready to present evidence? I couldn't hear you, but I assume that you will be.
Yes.
So we'll be in recess until 1 o'clock.
Who's here?
We're now back on the record. Mr. Redding, on behalf of the City of Henderson and its Utility Commission, do you have a witness to call?
We do, Mr. Commissioner. We would call Barbara Mall.
Oh, is she with you there, Mr. Redding? Oh, okay.
She is, Your Honor.
I'm sorry. I apologize. I didn't understand. Ms. Small, will you please raise your right hand? Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay. You'll probably need to
Ms.
speak
Mall.
up. You probably need to speak up, Ms. Mall. It may be hard to hear you.
Okay. Ms. Mall, on behalf of Henderson Private, would you state your name?
Barbara Mall,
And what is your business position?
Chief Financial Officer for Henderson Municipal Power and Light.
What is your business address?
105th Street, Henderson, Kentucky, 42420.
And do you adopt, you file direct testimony in this action, including an amended testimony?
Yes,
And do you adopt that,
yes,
including the exhibits that are attached both to your original testimony and your amended testimony?
yes.
Do you have any clarifications or corrections that you want?
I just wanted to point out that in my amended testimony, I did make a correction related to severance costs for an amount that was double counted. So my amended testimony and the exhibits have been corrected for that error.
With that, we turn the witness over to the parties.
Mr. Kamuth, Mr. Kurtz, any cross-examination?
Yes, Your Honor, a little bit, just on severance. Ms. Mulga, good afternoon.
Good afternoon.
Okay, on page 8 of your testimony, lines 14, 15, and line 21, you assert that Big Rivers charged the city severance costs without any contractual authority to do so. Do you see that?
Yes.
First of all, put the severance in perspective. What was the total amount of severance that Big Rivers paid the employees?
I believe that was $3.3 million.
I thought it wasn't it reduced to the later debt response?
Yes, it was reduced by it was $143,000 for Hempel portion.
So, and do you know that how many employees that covered?
I believe it was 62.
Okay. And is it your understanding that that was about $50,000 per employee, which was 6 months of compensation, including health insurance?
Yes, in summary, I have said 6 months at approximately 38.78 per hour, and that was 6 months of pay per severed employee.
Okay. And it's your position that was a non-contract, that under the contracts, Big Rivers was not authorized to make that severance payment, correct?
Yes.
I'm sorry? Is that a yes?
Yes.
Are you familiar with the power plant construction and operation agreement?
I know it exists. I've read portions of it.
Have you read section 13.4, which states, Big Rivers covenants and agrees that during the term of this agreement will at all times operate cities Station 2 on the best efforts basis in an efficient and economical manner, and will maintain, preserve, and keep said Station 2 in every part thereof in good repair. And then section 13.6 goes on to say, city will pay Big Rivers on a monthly basis it's reasonable expenditures incurred in the operation and maintenance of City Station 2. Are you familiar with those provisions?
I think their phone disconnected.
Quan, is the city still connected by phone?
Chairman?
I'm sorry. Can,
Oh, we think the city we might have lost contact.
I see the city, but I don't see,
We don't hear him.
Mr. Redding, can you hear?
He's calling, so.
And it's not showing up.
Hello? Okay, let us check it out.
Does that keep working?
It appears that the city is unable to hear the hearing, and we're unable to hear them as well. So, not sure if it's on our side or if it's on their side.
We can see the city, but they can't see us, and they can't hear us. So, there has to be a solution to this problem.
Let me check with Anthony. Check with Anthony.
I sent a message to Anthony.
I'm sorry?
I sent a message to Anthony.
Well, we have our IT person on call here in another office, who's going to come by and see if we can fix it.
Anthony says it's on their end.
It's on their end.
It's on their end somewhere. They've got to mute it or something. Yeah, he says it's on their end.
Apparently, our IT person says the problem is with the city of Henderson. So I don't know what, are they on the phone?
I'm going to call them back now and
I mean, I don't
recommend
know.
that they sign off.
They
and
can't
sign-
see us or hear us.
They can't hear us,
They
and we
can't
can't hear
us,
them.
they can see us.
Yeah. So let me call them
Maybe
and
they
then,
could call, use a telephone. Would that be, I don't know if that's possible or not.
I think Anthony just recommended for them to sign off and then try to
So
reconnect.
I try to go back on?
Yeah.
Chairman, you want to pause or you want to stay on record?
We'll go off the record until such time as we can get the city of Henderson reconnected.
Okay.
Okay, we're now back on the record.
Mike, can you
Mr.
hear us?
Redding, can you hear us?
Yes, we
I
can.
can.
Okay, thank you. Mr. Kirsch, you may continue your cross-examination.
I'm going to ask the witness, what was the last thing you heard? I'm not sure where to start.
You had just started reading from the contract, so I really didn't hear any of that.
Okay. This is a power plant construction and operations agreement, paragraph 13.4 and paragraph 13.6. Big Rivers covenants and agrees that during the term of this agreement, it will at all times operate City Station 2 on a best efforts basis in an efficient and economical manner, and will maintain, preserve, and keep said Station 2 and every part thereof in good repair, etc. And then it goes on, city will pay Big Rivers on a monthly basis its reasonable expenditures incurred in the operation and maintenance of City's Station 2 under the terms of this agreement. Did you hear and understand those contractual provisions?
Yes.
Okay. Let me just reiterate that a little bit. In response to Big River's data request 1-40, the city provided a 2011 bond prospectus that was issued for bonds. Did you have a chance to review that document?
I've seen that document, yes.
Let me read from page 26 of your response to Big Rivers 1-40. Big Rivers is responsible under the operation agreement for operating Station 2 in an efficient and economical manner. Its duties include, but are not limited to, providing all Station 2's operating personnel, material supplies, and technical services, and repairing and replacing equipment. The thing goes on say at the bottom, if at any time Big Rivers fails to provide, on a best efforts basis, continuous and economical operation of Station 2, the city has the right under the operation agreement to immediately take over the complete operation and maintenance of Station 2. Presumably, if you put it in a bond prospectus, we can assume that it's accurate.
Yes.
So doesn't it really boil down to whether or not the severance payments were reasonable? And if they were, the city had a contractual obligation to pay?
We believe that the employees were Big Rivers employees that they assigned to the Station 2 power plant. However, they choose to offer severance packages to their employees that were formally assigned to the plant is at their discretion, but we do not believe that those severance costs should be passed to us.
Well, Big Rivers paid the employees who operated your power plant wages, salaries, insurance, retirement, paid all those costs as the operator of the plant. Isn't that true?
Yes.
Okay. But your position is that the severance at the end of the life of the power plant was just simply, well, I guess your testimony was it's not contractually authorized, that you disapproved of it, and you essentially, well, you certainly object to it today, correct?
Yes.
Okay. You did have the option at any time to take over running the power plant if you felt Big Rivers was doing a bad job, did you not?
I'm not sure, but I believe that's the case.
Are you aware that the Kentucky Commission approves the payments of severance with respect to decommissioning Kentucky Power's Big Sandy 2 coal-fired power plant through the Kentucky Power Big Sandy decommissioning rider?
No.
Chairman, those are all the questions I have for this witness.
Thank you. Mr. Mann, questions?
No questions, Your Honor.
Mr. Matthews, any questions?
No questions.
The only question I have, Ms. Mull, is the bonds that the city issued to basically, I guess, build the plant, or for which Station 2 serves as collateral, have those bonds been paid off?
Yes, they were paid, the last payment was made on March 2003.
I have no other questions. Any redirect examination?
I would just like to clear up one matter. Barbara, on Law Exhibit 2, would you identify that gentleman for the commission, what that document is?
Yes, what that is it summarizes all of the unwanted excess Henderson Energy revenue and variable costs, as well as shortfalls for coal and lime inventory related to the unwanted energy, as well as some for native load.
And this was Big Rivers calculations.
Correct.
This is a Big Rivers document.
Correct.
And so to simplify for the commission, if the energy between June of 16 and December of 17, if Henderson pays the variable cost and receives the revenue, then what would the variable cost have been in that document?
From June 2016 through December 2017, those costs would be $10.6 million.
Right. And the document that you presented would indicate Big Rivers calculations that when Henderson supplied the coal under that scenario, correct?
Yes.
And when
Your Honor, excuse me, I just need to object for the record. This is not redirect because she was not asked any questions about that.
I agree with that, sustained. It isn't within the scope of information or the questioning on cross-examination or by the commissioners or staff counsel.
I was just trying to help the commission with calculations that would simplify having to besides do these numbers.
No, I understand, I mean, that could have been done as an additional direct examination, but it wasn't. So if, you may question with respect to topics that were raised or new information that was basically injected into the record by Mr. Kurtz or staff counsel. But beyond that, no.
And that concludes our, Ms. Small.
May this witness be excused?
Yes, sir.
Okay. Ms. Small, you may step down. And Mr. Redding, you may call your next witness.
Brad Pickett. Mr. Pickett, you're on, Mr. Commissioner.
Okay, I see it with his hand raised. Mr. Bickett, do you solemnly swear or affirm under the penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Okay. Mr. Redding, you may ask.
Mr. Pickett, would you state your name, Brad Pickett, and your position, sir? Reliability Compliance Manager for Henderson Municipal Power and Light, and your business address, 105th Street, 105th Street, Henderson, Kentucky, 42420. And Mr. Pickett, you have provided direct testimony in this case as well as data responses? Yes. And you adopt those? Yes. Mr. Pickett, for clarification, Your Honor, this time was just to ask a few questions about this direct testimony.
You may.
Right. The Station 2 agreements, were they filed with MISO for the grandfather treatment? They were not. And what is the effect of that? What that means is that the tariff would not apply under those Station 2 contracts. And if those tariffs do not apply, then should the fees, would they be assessed against Henderson? No, with the exception of fees that Big Rivers has charged due to their representing Henderson in the local balancing authority area that they maintain. Those fees, as Big Rivers just described, they are transmission fees. But there's various schedules that make up the sum, and for the most part, they're related to transmission, for which the Henderson actually owns its own transmission, which was not registered in MISO. What are the three types of registration available for Big Rivers in the MISO system? So when any utility registers with MISO, they have the option, and it's reasonable to assume they would register their assets that receive revenue from MISO, that being generation and transmission. The third asset would be load. So there's three assets that are available to register MISO, being generation, transmission, and load. Did Big Rivers register Henderson's share of the generation and MISO under Henderson's name? No, Big Rivers registered the generation, Henderson's generation. Yeah, Big Rivers registered the entire amount of generation out of Station 2 in Big Rivers' name and not Henderson's. And what effect did that have on Henderson? That denies Henderson the rights to revenue that would have otherwise been received from MISO. And that transmission revenue is approximately how much a month? It's approximately between 150 to 170,000. We can approximate this a little bit less than $2 million per year. And that's based upon the proceedings that are pending in FERC. Dealing with this exact question. Correct. Once Henderson elected and chose to join MISO, effective February 1, 2019, at that time chose to register its transmission assets as well.
Your Honor.
That's all right.
Your Honor, I want to object again because none of that information is in his direct testimony. And I don't know where it came from or how to verify it or anything. And therefore, I'm going to move to strike that last question and answer.
Any response,
response,
Mr. Reddy?
Yes, Mr. Commissioner, it is in that testimony, and he unequivocally tells you that we were deprived of those revenues. And much as Big Rivers has been asked to do to try to quantify those numbers, we have taken the same approach and quantified those numbers for the hearing, just as Big Rivers has done. Many of the numbers that Big Rivers, they suggested they would be costs, they would be activities, and they have supplemented their direct testimony by providing those numbers which the commission needs. So the substantive questions and answers are in the filings, and therefore these numbers follow directly from his filed testimony.
Overruled.
Thank you, sir. I think that's all we have from this witness.
Cross-examination, Mr. Kurtz?
Thank you, Your Honor. Mr. Bickett, will you turn to page 9 of your testimony, please? Line 12.
Okay.
Okay. I want to read the question and answer, but basically you are asserting that the MISO planning reserve margin requirement did not apply to the city before February 119. The question, if there is no specific NERC requirement for planning reserve margin applicable to Henderson, did Big Rivers have a basis for extending a MISO planning reserve margin requirement to Henderson before February 119? No. Under the power sales contract, Henderson alone had the right and sole authority to determine its annual capacity reservation from Station 2 and allocated the remainder to Big Rivers. Per the Station 2 contracts and under the NERC reliability standards, neither MISO nor Big Rivers have authority over Henderson's capacity reservation from Station 2. Did I read that correctly?
Yes.
Okay, and it's Big Rivers' assertion that the capacity reservation for the 2018-19 planning year should have been 125 megawatts versus your contention that it's under the MISO formula, the Big Rivers 125 megawatts, but it's your position that the city was authorized to nominate 115 and did not have to comply with the MISO formula. Is that correct?
That's correct, under the Station 2 contracts, correct.
So, that same bond prospectus issued in 2011, page 28, under the heading the System Reserves Agreement, and I'll skip to the middle. In 1998, the parties amended the System Reserves Agreement to require the parties to maintain reserves in an amount required by any applicable regulatory or government agency, any regional transmission authority, reliability, or like organization. I know you don't have the document in front of you probably, but is MISO a regional transmission authority?
MISO is a regional transmission organization, yes.
So the 1998 amendments require each party, Big Rivers and the city, to comply with MISO under the System Reserves Agreement.
I disagree. That amendment required Henderson and Big Rivers to comply with the NERC requirements, but it does not mention MISO. It does not apply to a RTO for which Henderson has not elected to be a member of.
Section 2.1 of the System Reserves Agreement as amended in 1998, which is page 10 of the 1998 amendments. Mr. Chambliss quoted it earlier. Did you have that in front of you?
I do not, but I am familiar with the document.
Okay. Let me read you the System Reserves Agreement as amended in 1998. The city and Big Rivers covenant and agree that each will comply with any system reserve capacity requirements now required or imposed at a future date applicable to it, as such requirements may be modified from time to time, and as such requirements apply to it given its respective operational characteristics by NERC, ECAR, any successor organizations to NERC and ECAR as applicable, any applicable regulatory or government agency, and any regional transmission authority, reliability council, or like organization. So earlier you agreed that MISO was a regional transmission authority. In the 98 amendments, Big Rivers and the city have each agreed to comply with the requirements of such regional transmission authority. But yet your position still is that you did not have to meet the MISO capacity planning requirements. Is that correct?
Correct. There are many regional transmission authorities in the United States.
Well, but Big Rivers is only a member of MISO. And you're
And Big Rivers and Big Rivers is required to follow the rules of MISO because they elected to join MISO.
your load is in MISO, correct? And it was.
Our load meters, if I may answer, our load meters were not added into the MISO commercial model until June 1 of 2018. So our load was not metered in MISO before February 1 of 2019, for which at that time we acquired a meter data management agent. Before February 1, 2019, Henderson had no meter data management agent, which is a requirement of MISO for a market participant with load.
And that's because Big Rivers did those responsibilities for you, correct?
Incorrect. Big Rivers and Henderson had an interchange protocol under the Station 2 agreements that basically settled on an hourly basis, energy by the hour, under the Station 2 agreement, and it was not metered for load to be in the MISO.
Would you agree that if the MISO rules and regulations did apply to the city of Henderson, that Big River's calculation of 124.7 megawatt capacity reservation for the 18-19 planning year was correct? If MISO did apply, would you agree the calculation was correct?
No.
And what aspect of the calculation do you think was wrong?
Well, the fact that Henderson did not have any generation registered in MISO. You're talking about load. If Henderson had generation registered in MISO, then it would be appropriate for Henderson to be credited with those, what they call zonal resource credits in MISO. The problem is that those zonal resource credits belong to Big Rivers and not Henderson.
The 125 megawatt capacity reservation is a function of how big your load is and how much reserves you need to meet reliability under the MISO formula, is it not?
That's incorrect.
Have you reviewed Mr. Akert's testimony?
I have.
Have you reviewed his response to staff? PSC 1-24, where staff asked Big Rivers to explain the difference between the 115 megawatts you have asserting versus the 125 Big Rivers is asserting. Have you reviewed that?
Yes, I have.
And in your calculation, what equivalent forced outage rate did you use for Station 2?
Which calculation are you referencing?
Well, the calculation Mr. Akert has in response to staff 1-24.
I don't have his testimony in front of me. What I will tell you is that Henderson has reserved capacity at Station 2 with the consideration of generation it receives also from the Southeastern Power Administration, and then takes into account the load requirement that it has. And we've applied the NERC plan reserve margin, which is adopted by CERC, of 15%. CERC is the region that Henderson, Big River both reside in within our area.
Do you understand under the MISO rules, not every megawatt of capacity is treated the same for reliability? For example, 1 megawatt of solar or wind, because it's intermittent, has a lower capacity value than 1 megawatt of natural gas combustion turbine or a coal facility?
I do that. Yes.
And the less reliable your resource is, the more megawatts you need to satisfy the reserve, correct?
Correct.
According to this data response, you used a industry average equivalent forced outage rate of 6.85%, whereas the 3-year rolling average, which is what MISO uses for Station 2, Unit 1 was 11% equivalent forced outage, and for Unit 2 was 21.2% equivalent forced outage. Were you aware of that?
I am. I would like to point out that you're referencing an email that I sent to Mark Eckert that has been taken out of context by Big Rivers for purposes of this hearing.
But would you agree that because the Station 2 units were near the end of their life and relatively unreliable, you had to have more megawatts of Station 2 to meet your reserves than if it was a more reliable unit with less forced outages?
Henderson did not have generation in MISO at all. Once Henderson joined MISO in February 1, 2019, the Station 2 units were retired. Henderson had no resource in MISO.
To move on to another topic, would you turn to page 7 of your testimony, please? Are you there?
Okay?
Okay.
Yes.
Line 5, this is a question about whether this NERC BAL-002 requirement applied to Henderson at the time Big Rivers joined MISO. And your answer is no, that NERC contingency reserve, the largest unit contingency reserve rule did not apply to Henderson because you were not a balancing authority and you were not registered as a balancing authority. Is that correct?
Correct.
I remember when all this was happening back in 2010, this NERC rule required small utilities like Big Rivers to join up with a bigger organization like MISO to use the resources of the larger organization, because trying to satisfy this on a standalone basis was completely cost prohibitive. Was that your understanding of what was going on in this time period?
No, not exactly. Not the way you characterize it, but I understand what the time frame when the NERC liability standards came into effect.
Do you know, for example, how LG&E and KU comply with this?
I do not.
Would it surprise you if they have some sort of joint reserve sharing agreement with TVA that East Kentucky was a part of until they joined PJM? Were you aware of that?
I was not.
Okay. So the reason the balancing authority function did not apply to you is because Big Rivers was doing it for you back when this NERC rule became effective. Isn't that correct?
No, that's incorrect.
Well, let me read you the 2009 Memorandum of Understanding between Big Rivers and the city. Subsequent to the unwind, do you know what the unwind was?
Yes.
Okay. That's when Big Rivers took back control of its power plants from the unregulated LG&E entities. Is that correct?
Yes.
Okay. So in 2009, the MOU between Big Rivers and the city says, subsequent to the unwind transaction, Big Rivers Electric Corporation will continue to provide and be responsible for compliance with all TOP. Do you know what that means?
Yes.
What?
Transmission operator.
Okay. Then it goes on GOP. What is that?
Generator operator.
And BA reliability standard functions. What is BA reliability standard functions?
Balancing authority.
Balancing authority. Related to Henderson Municipal Power and Light, as those functions were provided by Big Rivers Electric Corporation, Western Kentucky Energy Corporation, and LG&E Energy Marketing prior to the unwind. So what this says in plain words is that Big Rivers provided WKE, LG&E provided the balancing authority function for the city during the unwind, or during the lease transaction. But after the lease terminated and the unwind occurred, Big Rivers did the balancing authority function for you. Isn't that correct?
Big Rivers Big Rivers was a balancing authority. Henderson is within the balancing authority area of Big Rivers. So if you would restate it to that effect, Henderson did not require balancing authority services because Henderson was not registered as a balancing authority, nor were they Henderson required to be registered.
Well, isn't that circular? The reason you didn't have to do the balancing authority function is because Big Rivers was doing it for you. If Big Rivers had not, then you would have had to done it on your own.
Only if a new balancing authority area would be created, which it was, effective 3/1/2019. Before that, Henderson was within the balancing authority area of Big Rivers.
Let me read to you from your the 2018-19 fiscal year financial statements of the City of Henderson. This is a response to Big Rivers 1-31, page 13, under the heading Regulatory Compliance. The North American Electric Reliability Corporation, NERC, adopted new electric system reliability standards for all electric utilities in the United States. NERC adopted and began enforcement of the new standards beginning in June of 2007. The new standards were approved by the Federal Energy Regulatory Commission, FERC. HMP&L is required to comply with the new reliability standards and incurs administrative expenses related to NERC compliance. Is that a true statement?
Correct, yes.
So had Big Rivers not been your balancing authority, you would have had to comply with NERC on your own, correct?
No, Henderson did comply with NERC under the Station 2 contract. Specifically, Henderson was registered as a transmission owner, a distribution provider, and a load-serving entity. For those standards and subsequent requirements, Henderson remained in compliance with all those standards since the time that I've been working there.
Did you review the rebuttal testimony of Mr. Chambliss?
I did.
Did you review on page 5 his quotation from CERC, the Southeastern Electric Reliability Compliance Audit of Henderson, dated May of 2014, on page 5 of this testimony?
I recall, but I could not recite it word for word.
Okay, let me read it to you. He's quoting from CERC. HMPL was also registered for a coordinated function registration, CFR, with Big Rivers Electric Corporation for the following compliance responsibilities. TO functions, you define TO as transmission owner, right?
Right.
And LSC functions, load serving entity, correct?
Correct.
The reliability coordinator, RC, balancing authority BA, and transmission operator, TOP, for Hempel are as follows respectively. MISO is the RC, Reliability Coordinator for Hempel, and Big Rivers Electric Corporation is the BA, Balancing Authority, and TOP for Hempel. That was what CERC said in 2014. So isn't it true that Big Rivers was providing that function for you that you would otherwise have to do on your own?
No, that's basically saying that Henderson is in the balancing authority area of Big Rivers, and we're in the reliability coordinator area of MISO. And I'll add that when I contacted MISO to ask for something in writing saying they were our reliability coordinator, they simply, in some other words, I don't remember verbatim, that they didn't know Henderson even existed.
Well, perhaps that was true because Big Rivers was doing all the work for you. Because your financial reports conclude that the NERC requirements did apply to the city. That was in 2007. You call me that.
Henderson has been registered as a NERC registered entity since the reliability standards became effective, just like Big Rivers. However, Henderson is not registered for the balancing authority function.
I'll move on to a final topic. Obviously, you're disputing a lot of the MISO fees that Big Rivers is passing through to the city for going all the way back to 2010. Is that correct?
Correct.
And effective, I guess, February 1, 2019, you became your own MISO member, correct?
Correct.
So you started getting bills and invoices from MISO directly rather than having Big Rivers pass through those costs at that time, correct?
I disagree with the characterization that Big Rivers was passing through costs, first. Second, to your question, if you repeat it without that characterization.
Okay. Well, Big Rivers thinks they were passing the MISO costs through to you, but they were charging you, whether it was proper or improper, I guess, for the commission. But beginning February 1/19, you started getting billed directly by MISO, correct?
Correct.
And your load did not change between January 31st, 19 and February 1, 19. I mean, obviously load changes every hour, but there was no change to your load makeup, correct?
Well, obviously, like you mentioned, there's some change variable hour to hour, but generally, no, the load did not change, other than the fact that Henderson was actually being represented by a meter data management agent, and Henderson actually had its load at that point registered in MISO by the authority necessary for that to happen.
One way that Big Rivers tried to verify or confirm or investigate whether or not its believed pass-through of MISO fees to the city was reasonable was to look at the invoices that that MISO sent to the city since the city became its own MISO participant. Do you recall that request?
Yes, and that the types of fees and invoices for MISO are completely different and unrelated to what Big Rivers has billed to Henderson over the course of the year when we operated under the Station 2 contracts.
Well, the load-related fees would be the same because the load didn't change between January 31, 19 and February 1, 19. So whatever MISO was billing you for your load, we could compare to what Big Rivers was asserting it was a pass-through for your load. Wouldn't that be a look at that?
I don't think so. Basically, the fees that Big Rivers charged to Henderson were related to transmission. And Henderson's paying for transmission service now. That grandfather agreement that you're referencing, that those fees are based on, that got terminated when Henderson joined MISO. The fees that are billed for now have nothing to do with the grandfather agreement.
I wasn't referring to the grandfather agreements that provide transmission-related services to your SEPA entitlement or to Station 2, which was obviously retired. I was referring to the MISO fees associated with load.
Which fee would that be? There's various fees. I'm a little bit confused as to what fees you're talking about.
We could ask one of the Big Rivers witnesses. I think 3, 5, 6, 17, and 24.
All right, so what do you want to know about those? Because those are the breakout schedules of the fees that Big Rivers has charged to Henderson.
Well, to judge the reasonableness of Big Rivers trying to pass through MISO load-related fees under Schedules 3, 5, 6, 17, and 24, we thought it would be informative to look and see what MISO was billing you directly for those exact same services. Doesn't that seem to make sense?
Doesn't seem relevant to me. These schedules are basically used for grandfather agreement.
Again, I'm not talking about the grandfather transmission. I'm talking about the load-related fees.
That's the same thing. That's what these fees are based on. A grandfather agreement that Big Rivers submitted and filed with MISO, which is the transmission and transformation agreement between the two parties.
The grandfather transmission agreements relate to generation. I'm talking about the MISO fees related to load.
I think you might need to double check what you're saying because these fees are based on a grandfather agreement filed with MISO, unless I'm confused.
Well, I think you are. In any event, you refuse to provide the MISO fees that you're being charged directly, and you even said it. You said they're not relevant. Don't you think it would be relevant? Well, if MISO's charging you directly for something Big Rivers was trying to pass through to you, wouldn't it be relevant to see if they were far off or exactly the same or close?
It's completely irrelevant because the basis, the Henderson load was registered as part of Big Rivers load. Henderson load was not even metered in MISO until June 1 of 2018.
It was part of Big Rivers was getting a bill from MISO for your load, and they passed through exactly to you the cost for their load, even, Stephen, 100% the same as MISO charged Big Rivers for its load. Is that not the way you understood it?
No, Big Rivers never had the authority to register Henderson's load asset in MISO, period.
So you think you could just have your 625,000 megawatt hours a year sitting in the MISO area for free? Somebody had to pay.
Henderson generated the power at Station 2, and Henderson owns the transmission line from Station 2 to the city of Henderson. It never went into MISO. If it did, it was not approved or authorized by the city of Henderson.
Your load was in MISO. Big Rivers was charged for your load. Is that not the way you understand it?
Who authorized that?
MISO? Mr. Chairman, no further questions.
Mr. Nguyen, questions?
No questions, Your Honor.
Commissioner Matthews?
No questions.
I have no questions. Mr. Redding, any redirect?
Just quickly, Your Honor. Mr. Bickett, the unit shut down on February 1st of 2019, Station 2 units, correct? January 31st, right? At that time is when Henderson registered its units for its generating and its transmission capacity with MISO. No, the units were retired. So the units were effectively taken out of the MISO interconnection system.
Did we ever register them with the?
No. That's all I have.
May this witness be excused? Sir, you may step down. You're excused.
Thank you.
Mr. Redding, you may call your next witness.
Seth Brown, Your Honor. I
Mr.
believe Mr.
Brown.
Brown has just joined the IO. Mr. Brown is in Atlanta.
Yeah. Mr. Brown, would you please raise your right hand? Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir, I do.
Mr. Redding, you may ask.
Mr. Brown, would you state your name for the commission, please?
Yes, it's Seth W. Brown.
Mr. Brown, what is your position and title?
I'm the Vice President of Transmission Services at GDS Associates.
And what is your business address, sir?
1850 Parkway Place, Suite 800, Marietta, Georgia, 30067.
Have you filed direct testimony in this pending PSC action in the state of Kentucky?
Yes, I did.
And do you adopt that testimony?
Yes, I did.
Filed?
Yes.
Do you have any clarifications or changes that you want to provide to the parties or to the commission?
No, sir, I do not.
I pass the witness.
Mr. Kurtz, cross-examination.
Thank you, Your Honor. Does MISO bill for, does MISO have load-related schedule charges?
Yes, there are many service schedules that are load-based charges.
Was Big Rivers billed by MISO for the city of Henderson's load?
Sir, I do not know that.
Do you understand that Big River's position is that they treated the city's load and their load exactly the same and just charged the city exactly what MISO charged Big Rivers?
Counselor, I do understand that there were MISO charges that Big Rivers passed through to Henderson, and that was in your detailed in Mark Eckritt's exhibit number 3.
Now, there's a dispute or a question about whether the grandfather transmission agreements were properly registered, and you've addressed that in your testimony.
Yes, that is correct.
Would you agree that whether, and did you read Mr. Eckritt's rebuttal testimony where he says FERC approved them via some letter order?
No, I did not.
You did not read his rebuttal?
I do not recall that statement, no.
Do you agree that regardless of the registration proprieties, whether it was registered correctly or the FERC order, that the city of Henderson received the benefit of the grandfather transmission agreements?
I'm not sure what you mean by benefit of grandfathered agreements.
Well, we call it the grandfathered agreements provided for lower cost transmission, not service, administrative fees than new transmission. So they received the benefit of being grandfathered, regardless if they were registered.
Did you pose a question? I'm sorry. Could you
Yes.
repeat?
Would you agree that the city got the benefit of the grandfathered agreements regardless of how they were registered or were not registered?
No, sir. I mean, benefits is kind of a broad term. You'd have to be specific about that. Benefits in MISO could be things such as better reliability, lower cost of power, increased availability of economic energy. So you have to be specific as to what benefits you're referring to.
In your testimony, you used the phrase, I think, double charge or double recovery in a couple places. Do you recall that?
Yes, sir, I do.
So do you think that MISO sent an incorrect bill to Big Rivers that included some sort of double recovery or double charge?
That I'm not sure of because I don't have the information related to the actual billing that MISO sent to Big Rivers, for what particular service schedules. I can only comment on the charges that Big Rivers passed through to Henderson.
Well, to the extent that MISO made a mistake, wouldn't you agree, Mr. Brown, that the city could go to MISO to have that fixed?
Well, Counselor, if you read the tariff, I was pretty specific about that, that there is an obligation there for the transmission owner to certify that to MISO, which is the transmission provider, that no such double recovery is occurring. So there's obligations in the tariff for both the transmission owner, which in this case is Big Rivers, or was Big Rivers at the time, and MISO as the transmission provider.
Let me see if this is the way you understand. MISO sends a bill to Big Rivers. ACES immediately reviews that. You know who ACES is? ACES Power Marketing?
Yes, I do.
Who is that?
I'm familiar with ACES Power Marketing. They are a power marketing organization. They do various services for their cooperative clients.
Yeah, and there's several co-ops in MISO. Are there not? Wabash, Hoosier, I think.
Yes, GDS has several co-op clients in MISO.
Okay, so MISO sends a bill to Big Rivers. ACES immediately gets it in shadow bills to verify the accuracy of the MISO bill. Do you understand that that's how that works?
Yes, sir.
Okay, and then Big Rivers takes the MISO bill that's been reviewed by ACES, it reviews it, and then passes through what it thinks is the cost that the city caused, the city's generation plan caused. And that's Big River's position of what's been done. A pure pass-through with no markup, no profit margin, no nothing.
Well, Counselor, there would have to be calculations done. There would have to be some basis, economic basis for passing all or a portion of those MISO charges to Henderson. What process ACES potentially went through to do that, that's not clear to us. It's not in testimony.
Mr. Brown, thank you. Chairman, no further questions.
Mr. Nguyen, questions?
No questions, Your Honor.
Commissioner Matthews?
None.
I have none. Mr. Redding, any redirect?
No, Mr. Commissioner.
All right, Mr. Brown, you may be excused. Thank you for appearing
Thank
and
you.
for your testimony.
Thank you, sir.
All right, it's 8 after 2. Why don't we take a 15-minute break until 25 after, it's 10 after, 25 after 2, and then we'll come back and finish up with what I believe to be Henderson's last witness. Okay? So we'll be in recess for 15 minutes. Okay, we're back on the record. Mr. Redding, I believe you have one more witness, is that correct?
Yes, yes, yes.
All right, please raise your right hand. Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do. Would you state your name for the commission, please?
I'm Christopher Heimgartner, but please call me Chris.
And what is your position, sir?
I'm the general manager for Henderson Municipal Power.
And what is your business address?
105th Street, Henderson, Kentucky, 42420.
And have you provided testimony including a first and second amendment with exhibits to your testimony?
I have.
And do you adopt that testimony?
I do.
Do you have any clarifications on that particular, on your existing testimony?
Not at this moment.
Mr. Heimgartner, in regards to the ash pond that Mr. Pullum has spoken about, has Hempel agreed to be responsible for the decommissioning of the ash pond? And if so, explain what the dispute is about.
So the short answer is yes. Henderson has agreed to be responsible, partially responsible for the decommissioning of the ash pond. And the ash pond is covered under the joint facilities agreement for the site. The ash pond itself received ash from Reed starting in 1973, and as well as Station 2 starting sometime about 1972. I'm not exactly sure when. So the pond received ash from both of the power plants over its life. And when you calculate the extent that either party used the ash pond, you take a look at the share of Station 2 that Henderson had and the capacity of Reed. That's how you determine the total use for the pond over its life. When you include Reed, the actual percentage is 18.87%, if I recall correctly.
I think it's in the right-hand corner of this document, Mr. Heimgartner.
Okay, 18.87%. And if you don't include Reed, then it's the higher 22.61% that Big Rivers is alleging. And that's the entire difference. Now, we've been billed for preliminary work out of the pond. I'm not sure exactly physical work or studies or what, but we were billed at the 22.61%. We offered checks at the 18.87% rate, and those checks were returned. So we definitely have agreed to participate in the decommissioning of the ash pond.
And regarding the high wall at the Claim landfill, Heimgartner, you have an objection to be responsible for the high wall on an ongoing basis. Can you explain why?
Well, the high wall really benefits, it doesn't benefit Henderson customers at all. We're done participating in adding to the landfill, and the high wall was for some future use of the landfill for Big Rivers customers.
The contracts require that anything Henderson gets built in Big Rivers has to be applicable to statutory law. Do you know whether or not the high wall was submitted to Henderson for a bid and properly approved under the statutory bidding requirements?
My understanding was it was not city bid.
You're also objecting to the severance fees. And can you explain why?
Chairman, I'm going to object. The scheduling order pursuant to commission practice does not allow for summation of witness testimony, which essentially is what all this is. If there are changes or corrections, that's one thing, but to just have direct examination, which is effectively a summary, is not proper.
You have any response, Mr. Redding?
Well, we are providing the explanation, just as Big Rivers has done all of their testimony as to our position, why Big Rivers' positions are incorrect, so that the commission can get a totality of the circumstances, including the issues that are tantamount to this proceeding.
I'll permit it to some extent, overruled.
I'll move on quickly. On the severance, can you quickly summarize?
Sure. So on April 25th, 2018, the Henderson Utility Commission had an open meeting where we discussed our IRP. Bob Berry attended that meeting, and at some point, the IRP recommended that we close our part of Station 2. Somebody turned to Bob, and I think it was one of our commissioners, and asked the question, what does this do to the people? Now, Bob at that time said that the people there would be treated just as they were at Coleman, and that it would all be handled through attrition. There was no mention of any severance or anything like that, and we were actually gratified to hear that you had places to reassign these folks, and so we moved on with that. And that, I think, is one reason why it was such a surprise. We got the severance in the calculations.
Mr. Heimgartner, were you a party to the resolution of the Henderson civil action that I've referred to as the 2009 CI damages claim?
Yes, I was.
And were you privy in those meetings?
Yes, I was.
What was the basis of the complaint for the 2009 civil action of which Henderson was trying to recover money for?
That was for the profitable excess Henderson energy that was taken and sold.
Now, Mr. Berry, in his testimony, has inferred to the commission that you have created a new animal called unwanted energy. When was the first, your unwanted or uneconomic, as Mr. Smith called it, would be that energy that's the variable cost exceeds the revenues? Correct?
Your Honor, I'm going to renew my objection. This is now it's even new testimony, not even a summation.
Yeah, I'm sorry, Mr. Coach, I couldn't understand you. The video sort of blurred out, and I couldn't hear you either.
Yes, sir, I was in objection because this is beyond even just something now, it's new testimony.
Mr. Commissioner, this is not new testimony. This is at a minimum rebuttal of Mr. Berry's testimony that this commission allowed him to embellish and talk about things that were far out of the scope. All this is explaining.
Well, let me say this. Let me say this, Mr. Redding. We understand, I'm an attorney, and we have attorneys here. I understand the position of both Henderson and Big Rivers with respect to the 2009 lawsuit and the settlement agreement. And, you know, it's the issue is probably whether it's ambiguous or not. I'm not clear in my view. It isn't. But I don't know the extent that you can take eccentric evidence from a witness who was not even employed or even in the state of Kentucky at the time. It probably is some new evidence. If it were marginally important to a decision in the case, I'd say go ahead and take all the time you need. I don't think it is. I'm willing to give you some latitude, but I don't think we need an elaborate history about this agreement and the pleadings in the 2009 lawsuit.
If I may, Your Honor, I have 3 points and then I will be finished.
Okay, sure, go ahead. I want you to be able to ask the questions you want, but at the same time to try to keep it within an acceptable range or context. I think something may have happened to Big Rivers. Hold on a second. Can you see on the screen? Can you see Big Rivers? Well,
No, it's a little blurry.
Mr. Kurtz, can you hear?
Yeah, Mr. Kurtz.
Yes, we can.
Well, I don't know. We can barely hear you, and your face is all blurry, and so is Mr. Camus. So we may have to take a second. You may have to log off and come back on or something, just like Henderson did earlier.
Okay, we will try to do that.
Okay, we will go off the record until such time as we can get perhaps Big Rivers back on. We're back on the record.
Well, I'm not on yet, don't say anything.
Mr. Hungarter, he's gone to the,
You can go, Mr. Chairman.
I'm sorry?
You can go, Chairman.
All right, we're back on the record. Mr. Redding, if you'd like to continue.
Mr. Hungarter, Mr. Hungarter went to the restroom.
Okay.
Barbara, he'll know to come. Mr. Heimgartner, one final question. Mr. Berry referenced his 2000, he couldn't remember what he had said in the 2016 hearing. What was the subject that Mr. Berry told the commission that was involved in that proceeding?
And this is from page 7 of 3, starting on line 16 of Mr. Berry's testimony. It is the responsibility for the variable cost of producing the remaining excess Henderson energy, which I refer to as the unwanted excess Henderson energy that is the subject of this proceeding.
And that's out of the 216 filing?
Yes.
That's all. I've passed the witness.
Mr. Kurtz, cross-examination?
Thank you, Your Honor. Mr. Heimgartner, will you turn to page 20 of your testimony, decommissioning costs?
And you amended Chris. I do have something in there. This is the second one right here. Yes, sir.
Okay. It's your position that your Station 2 power plant was decommissioned as of April 2019, and that the city has no additional cost obligation with respect to decommissioning. Is that correct?
Yes, sir.
If we drove by the plant today, wouldn't we see a 350 foot high chimney?
I can't speak to how high it is, sir. You can see a chimney.
Well, I mean, I don't want to be, you see where I'm going. The boilers, the turbines, the scrubber, the SCR, it's all still there. But, and your position is, that despite the fact that the plant is still standing, it's fully decommissioned. Is that correct?
That's correct.
Are you aware that the AEP Kentucky Power, their version of, or their understanding of decommissioning the Big Sandy 2 power plant, which the commission has approved through a rider, is to tear it down to a greenfield or brownfield site?
No, sir, I'm not.
Did you read that in Mr. Berry's rebuttal testimony?
I don't recall reading that, sir. It's possible that I did.
Did you read in his rebuttal that LG&E's Patty's Run power plant, their definition of decommissioning is to return it to a greenfield site, full demolition?
Yes, I do recall reading that.
And same with LG&E's Cane Run, decommissioned power plant, fully demolished and returned to a greenfield site?
Well, sir, I remember reading the rebuttal testimony, and it talked about several power plants. I don't recall the exact names of each one. I'll concede to you that there was a lot of information in there about decommissioning other power plants.
Okay. EKPC's Dale power plant, same thing?
I will accept your assertion that that was in there, sir.
Mr. We will stick, what's in the record is in the record. Right? Just continue that, does not seem overly productive.
Okay. The city used to own, before there was Station 2, there was Station 1, correct?
Yes, sir, that's my understanding.
And that was right along the river in Henderson. It was a series of small coal-fired power plants, 5 megawatt, a 5 megawatt, a 10, and a 26 megawatt power plant, or a boiler, I guess, or turbine. Is that correct?
I believe so. I also think there were some small diesel generators there, or maybe they were startup motors. I'm not entirely sure.
Right. And that plant was retired in 2008, Station 1, correct?
I would have to check on that, but I'll accept that.
If we drove by that site today, wouldn't we see a brownfield site because the whole thing has been demolished?
Yes, sir.
You were asked questions about the Station 2 ash pond. Do you agree that under the contracts, the ash pond is included as part of the definition of Station 2? In other words, the Station 2 ash pond is part of Station 2?
I know it was handled under a different contract. It was covered under the joint facilities agreement. So I don't know, I mean, is the full pile part of it? I'm not, the ash pond received effluent from Station 2. That's what I understand.
Okay, well, let me, the 1993 amendments, page 5, defines Station 2 as 350 megawatt generating facility, now rated at 315, located beside the Green River. and to the extent furnished and owned by city, joint use facilities. Do you recall that definition of Station 2?
That sounds correct, sir.
Okay. And then Exhibit 1, page 1 of 3 to the 1993 amendments titled Joint Use Facilities Provided by and Owned by City, but located on Big River's property includes number 13, 1 ash pond and effluent lines. Is that your understanding?
That's my understanding, yes.
So under the definition of Station 2, which includes joint use facilities provided by and owned by the city, that would include the ash pond, correct?
I think if you want to use that definition, yes, that'd be correct.
Now, you've, in discussion with your council, have indicated that you're willing to pay for part of the decommissioning of the ash pond. That is the 18.87% figure you cited, correct?
Yes, sir.
But you understand that Big River's position is that the decommissioning formula in the contract results, it doesn't include READ, for example, which your calculation apparently does, that it's 22.76% per the paragraph 8 of the 1993 amendments. Is that your understanding of Big River's position versus yours?
I would accept that with the stipulation that the higher percentage, the 22.76%, is predicated on a reservation of 125 megawatts in the final year of operation of Station 2, which is not true. Our reservation was only 115 megawatts, which is why the Station 2 final capacity split we're asserting is 22.61 or 62%.
Okay, what was your number, 22.61%?
I should remember this a lot better. Yes, sir, 22.61.
Okay, well, that's pretty close to 22.76, but and depending on how that capacity reservation issue is resolved, the 125 to the 115. But in any event, that's different than the 18.87% number you cited earlier, correct?
Those two numbers are different, yes, sir.
Okay. And one difference is that you believe that the Webster County Circuit Court should decide the decommissioning percentage and not the commission, correct?
Yes, sir.
With respect to the green landfill, would you agree that if you go back, if you start in 1995, the city has 2.6 million tons of scrubber sludge and ash pond dredgings in the green landfill? I think we heard if you go back to the beginning of Station 2 in 1973, the number is approximately 2.8 million tons of city waste in the green landfill. Is that correct?
Those are the numbers yes, those are the numbers that came out this morning.
Now, with respect to the green landfill, the city is contesting Big River's cost-based landfill rates from 2015 to 2019, and you believe that the $1.78 per ton number from 16-17 should be applied during the entire period. Is that correct? And therefore, you have a $1.75 million adjustment in Ms. Mall's exhibits?
Yes, that's correct.
Would you agree that during that same 4-year period, the cost-based rate for the green landfill was as high as $6.85 per ton?
I understand that's what Big Rivers is asserting, yes.
And do you understand that Big Rivers charges the city exactly the same amount per ton as it charges itself?
No, sir, I don't know that.
You are not obligated to put your scrubber sludge or ash pond dredgings in the green landfill, you could have elected to dispose of that power plant waste elsewhere, could you not?
Well, so I don't know what the options existed back in 1972. I was 12 years old. So over time, the Big Rivers has made the offer to dispose of the waste, and they've offered a price, and Henderson has accepted that. And that's how we got here today.
Well, that's my point. I mean, you could have at any time decided not to use the green landfill and go somewhere else, could you not?
Well, the ash that came out of basically that wasn't our decision. That was the operator's decision, and that was Big Rivers.
Under the contracts, you could have disposed of your waste elsewhere. Big Rivers wasn't making any profit on it. Why would they care where you disposed of the power plant waste?
I don't know why they would care.
Okay. And in fact, anytime since the plant went operational, you could have, as the sole owner, as the owner of the power plant, you could have exercised your right to say, Big Rivers, you're fired. We're going to operate this facility ourselves, or we're going to bring in a third party. You had that right, did you not?
That's my understanding, yes.
Now, the second stage of the green landfill is the ongoing storage costs since Station 2 quit putting waste into the landfill. And your position is that you owe essentially nothing with respect to ongoing storage or maintenance costs of your 2.6 or 2.8 million tons of power plant waste.
Yes, sir.
Is that correct?
That is correct, sir.
And if and when the green landfill, I guess when the green landfill itself gets capped and retired, your position is that you're not responsible for any costs associated with 2.6 to 2.8 million tons of power plant waste in the green landfill. Is that correct?
No, sir, that is not.
Okay. How much of the green landfill decommissioning costs on a per ton or percentage or dollar amount do you agree that you're responsible for?
I think that what has to happen is the parties have to take this before some kind of judicial court and get a ruling, and then, because there's nothing in the contracts that tell us on what to do with the green landfill. They're silent on that.
Well, the ash pond dredgings under the same provisions of the 93 agreements are also a joint use facility included in the definition of Station 2. Do you agree?
Yes, sir.
Okay. So the ash pond dredgings would be subject to the same decommissioning cost sharing formula, whether it's 22.76 or 22.61%. Would they not?
22.76 or 61% of what?
Of the total.
Which total?
In other words, we've got the green landfill. You're not responsible for paying any of the green costs, so that gets taken out. If there's any reed waste in there, that gets taken out. Whatever's left over is Station 2 waste, and you would be responsible for 22.76% of that, or 22.61%, I guess was the number you were using earlier. Wouldn't that be?
I think that's right, sir.
Okay.
So what to do with that?
Okay, so you would agree to pay that amount, or do you think a court needs to force you to pay it? I didn't quite understand that.
I think that you need to take this to a judicial body, have them rule on it, and then we see where it goes from there.
Okay. So you dispute the commission's exclusive jurisdiction over the rate and service standards and the commission-approved contracts, as well as obligations, rights, and privileges arising out of those contracts. You dispute the commission's jurisdiction?
Well, sir, Sir, I am not an attorney, and you're asking a question that really is appropriate for an attorney. So this whole thing seems to me to be a contract dispute between two parties. And normally you take contract disputes to a civil court. And that's where I think this belongs. I can't be more precise than that because I'm just not a legal scholar. I just don't, that's not my background.
Well, the legislature, in enacting KRS 278-200, vested the commission with jurisdiction over those issues, as the commission ruled February 4, 2020. Isn't that correct?
No objection, Mr. Commissioner. We're citing statutes and we're trying to determine the jurisdictional issue, which we all understand has been contested and continues to be contested.
He's not an attorney, so sustained.
Well, I'll withdraw. Thank you, Your Honor. Mr. Heimgartner, you're aware that Mr. Smith has two exhibits in his testimony as to what Big Rivers contends the city owes it as of June 30, 2020, under two scenarios. One is the decommissioning cost sharing percentage, and the other is retirement in place, which Big River's position is you would be responsible for 100%. Did you look at those exhibits in his rebuttal? No, I know you don't agree with them, but did you at least look at them?
Yes, I did, sir.
Okay. Let's take the bigger number, the 100% retirement in place is $4.328 million is the Big River's position. If the commission, and the lower number is 2.3 million, so 2.3 or 4.3. The commission at the end of this case orders the city of Henderson to pay 2.3 or $4.3 million to Big Rivers. Will the city pay?
No objection, Your Honor. That's not an appropriate question for this hearing.
Sustained. I suppose they'd have a right to appeal.
Well, but the appeal wouldn't stay the effectiveness of the commission's order.
I sustain the objection.
Thank you, sir.
Assume that the city refused to pay and the commission went to the Franklin Circuit Court to compel obedience to its order, and the circuit court agreed and did compel obedience, would the city comply with the circuit court decision?
Same objection.
Sustained.
Same objection, Your Honor.
Sustained. Speculative at least.
Okay. That may be my last question. I believe it is. Thank you, Your Honor.
Mr. Nguyen, any questions?
Yes, Your Honor, just a couple. Good afternoon, Mr. Heimgartner. Have you,
Can you hear me?
Yes, we can hear you. Can you hear me okay?
Yes, I can, thank you.
Okay, great. Have you had a chance to review Mr. Berry's rebuttal testimony prior to the hearing?
I have.
Okay.
I have, yes.
Do you
It's been a while, but-
Do you have Mr. Berry's rebuttal testimony there with you?
Could you give me just a minute?
Sure.
No, it's hang on here. Nope, I'm back. That's everyone's.
Yeah, his should be the first one of that stack.
I think I have it, sir. If you could direct me where you want me to go?
Sure. If you go to page 21, at the bottom of page 21, yeah, about 2/3 down, page 21, beginning at line 14. And if
The
you,
payments covered solely.
Yes, the sentence starting with the payment of severance solely benefited Henderson. Can you read this paragraph, which ends on the next page, page 22 at line 3? Could you read that sentence, please, or that paragraph, please?
I'm sure you know where you
Can you read that out loud into the record, Mr. Heimgardner?
Certainly. It says the payment of severance solely benefited Henderson. Had Station 2 been retired as soon as it was uneconomic, the city would not have had a power supply. Station 2 was uneconomic to Big Rivers for at least 10 months before its ultimate closure on February 1, 2019. And Big Rivers only agreed to operate Station 2 through that date for the city's request to ask to have adequate time to find an alternate supplier. Given Station 2's pending closure, Station 2 employees had good reason to seek employment elsewhere during that period. A situation similar to what Henderson experienced when announcing the closure of Station 1 generating facility. The availability of severance provided an incentive for Station 2 employees to remain working at the facility so that Henderson can continue to have a power supply. Henderson should therefore be held responsible for its share of severance costs.
Okay. Do you agree with this statement?
No.
And why not?
First of all, in the last, 4 or 5 years, there's probably been 500 coal units closed around the country. There are a lot of unemployed coal power plant workers out there. So, number one, people leaving right now go into a busy labor market. And number two, you can draw from that labor market should you need them. The second thing was, we had been told that the severance was unnecessary. And the severance didn't need to be paid, and Big Rivers could have reassigned those people and kept them internal. So that there simply was no benefit to Henderson whatsoever. And third, the Public Service Commission had listened to speedings by Big Rivers and agreed that there should be some period of time allowed for Henderson to get power available from the market. And I believe that the commission allowed until May of 2019. In fact, we were able to accomplish that by February 1st of 2019.
Okay. With respect to the costs associated with the disposal of the Station 2 landfill in the Station 2 waste in the Green Station landfill. Can you confirm that Henderson had previously approved and paid for those costs for the period between 2015 through 2017?
Henderson, as part of its annual budget, approved disposal of the waste, and I would characterize that as a tipping fee. We paid Big Rivers, they apparently paid a third-party contractor, and they hauled off the waste.
Could you repeat that again, Mr. Heimgartner? I didn't catch what you said in the middle of your response.
So my understanding is that Henderson, in its budget, would allocate a certain amount of money to allow for disposal of the waste, kind of a tipping fee. And then Big Rivers hired a third-party contractor, I believe, Chara? Is that the name of the contractor? Chara. And they, so it's a tipping fee, essentially, to dispose of the waste.
Okay, but whatever the bills that were submitted by Big Rivers, Henderson from 2015 through 2017 did not have any issues, objections, or contest those particular bills that were issued by Big Rivers to the city of Henderson regarding the Station 2 waste being disposed of in the Green Station landfill.
So when I arrived, we had a number of outstanding budgetary issues between the parties. And frankly, Bob Berry and I worked very hard to try and resolve that. So there was a lot of give and take. So I would say that those budgets were reconciled and payments were agreed to. where maybe both parties weren't exactly happy with the outcome.
But that was done after the 2015 to 2017 period, is that correct?
I arrived early in 17, so it would have had to been after that.
Okay. Can you explain what the city's long-term plan for the Station 2 facilities are? Does the city intend to maintain Station 2 in a retired-in-place state?
Well, our understanding is that Big Rivers currently owns the plant. And that was the subject of, and is currently the subject of one of the suits that we have in Webster County. So, our long-term plan is to attempt to get through these proceedings and resolve all this. But really, it's Big Rivers' plan, what they need to do with their plan.
Okay. Those are all the questions I have, Your Honor.
Commissioner Matthews, questions?
I don't have any.
I have a couple that are related to the status of the Henderson Utility Commission, DBA, Henderson Municipal Power and Light. And the witness may answer, or Mr. Redding, is the Utility Commission, the Henderson Utility Commission, a separate legal corporate entity, or is it a bureau or subdivision of the city of Henderson for which the city of Henderson is responsible?
I will do my very best to answer that. Obviously, we are created under KRS 96-520, and that gives us authority to act as an autonomous entity for certain activities, although the city continues to be the owner and appoints the utility board to manage the facility for the city. So I guess my best answer would be we are a hybrid extension of the city with autonomous authority under 96-520.
It's not a separate corporate entity, though, is it? With the power of eminent domain and that sort of thing? The reason, you understand the reason I'm asking is whatever the, does a finding or an order that applies to the Utility Commission, is that binding on the city, or what's the city's position on that? And if you prefer to brief it, you can brief it, but I'd like to know.
I think I would like to look at that, Judge, before I make some off-the-cuff legal opinion.
Yeah. Well, that'd be fine, but I noticed that I was on a city utility commission once, and Judge Thapar, who's now in the Sixth Circuit, had real problems with what the legal status was of our utility commission. So I thought I'd ask you, does the utility commission, is it able to raise rates without the approval of the city council?
We cannot. We can recommend to the city, but it requires our ultimate approval. City.
I'm sorry, I couldn't, it requires approval of the city council?
It does, Mr. Commissioner.
Okay, thank you.
That's very specific and
I think at some point you might want to address that. I'd appreciate if you would in your brief, and we'll talk about briefs in a second. Do you have any redirect examination, Mr. Reddy?
No.
Is that the case for Henderson?
Yes.
So both sides have rested. Let's talk a second about post-hearing data requests, I guess. Staff will send, I guess, as requested, 2 or 3 or 4 items, and Henderson has requested one, being the application, I think, for maybe one or all of the permits. So let me say this, because of the type of hearing it is, someone may say, well, I want something else. That'd be fine too, as long as it's only it has to be a document. If it isn't a document, whether somebody objects to it or not, we're not going to permit it, any post-hearing filing which explains anything or might be interpreted as being evidence, because it's not subject to the other party being able to respond to it. So if we have these post-hearing data requests, and there aren't many, and most of them seem to be permits or applications for a permit, is there any objection if we ultimately enter an order saying that the data request must be filed and served by the end of the day on Monday the 26th, October 26th? That would give you, this is Thursday, Friday and Monday? Is 2 days enough time to draft the data request, Mr.?
Oh, yes.
Mr. Redding?
Could we extend it to that Tuesday?
Yeah, you could, Tuesday would be, the 27th? Sure, you can handle Tuesday. So we'll do it on Tuesday.
I'm just sort of behind it.
I know how that is. Tuesday, the 27th. And then, is there any reason why the responses to the data request can't be served by November 2nd? I know that's election day, but I assume all lawyers work. Lawyers don't get election day off, do they? If you need more time, I'm willing to give you all the time you want. I just want something's reasonable.
That's fine with Big River, Your Honor.
That'd give you a week. Is that all right with you, Mr. Redding?
Yes, sir.
I mean, the only person that's responding is Big Rivers, so that gives them a week. All right, now, I assume that the parties would like to file briefs, and even if you don't, I'd love to. I'd love for you to. My thinking on it is that Big Rivers files its brief, Henderson files its brief in response, and Big Rivers gets a short time for a reply brief. So let me ask you first, Mr. Kurtz and Mr. Kamouf, how much time would you reasonably like to file your brief?
Can we just have 1 second, Your Honor?
Yes. And Mr. Ray, if you'd like to meet with your client on that too, and I know attorneys are busy, and it's sort of the end of the year. All right, Mr. Kurtz, have you?
Yes, sir. Big Rivers will file the brief 1 week after those data responses are due, so that would be November 9.
If we do that, Mr. Redding, I want to make sure if Big Rivers has a week, is a week long enough for you?
I would think not, Your Honor. We would ask that it be 2 weeks after November the 9th, whatever that date may be.
All right, here's what we'll do. We'll enter an order. An order will be entered that after the data requests, responses are filed, after whatever the day is, November 2nd, that basically Big Rivers will have 2 weeks to file its brief. Henderson will have 2 weeks thereafter, and then Big Rivers will have 5 days for a reply brief. All right?
That Monday is the Monday after Thanksgiving that your brief is going to be due.
One clarification. Could we make our brief be, that's the Monday after Thanksgiving, could we set that the next day, which would be the
December 1st?
December 1st?
let's see.
I just wanted to,
Big Rivers' brief would be due on what, the 16th? No, I'm looking at the wrong year. I got a 2021 calendar. Hold on. I apologize. So you get the 3rd, the 17th, so what would you propose, Mr. Redding, the 2nd?
I thought you said that theirs would be due November 23rd and ours, we were just asking for December the 1st.
16th. Yours would be due the 30th, right? If it's the 2nd, all right, if we have everything filed by, you want the 3rd, all right, so it'd be the 17th and then December 1st. Your brief would be due December 1st, correct?
Yes.
Okay. And then, Big Rivers would have, essentially a week, the 7th, December 7th, and then the case stands submitted on the record. Any objections to that schedule?
No objection.
No, sir.
Okay. All right, is there anything else that, the parties think the commission needs to hear or consider at this time? If not, we'll formally adjourn.
Chairman?
Yes.
Just 1 second.
Yes.
Can we just,
Oh, wait, staff counsel wants to speak with me for a second, so
Yeah.
we'll take a short break. Yeah. We'll adjourn the hearing. This hearing is now adjourned.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.